See the participants.
Could our participants please turn their video feeds on for the judge?
Good afternoon. This is Judge Garrido. I am the real judge in Division H in the Jefferson County Courthouse. Welcome, everybody. I'm looking forward to seeing this competition and being a part of it here today. First, I just want to make sure that I have both teams logged on and that everybody can hear me.
Yes, Your
I can
Honor.
hear you.
Okay, do I have the scoring panelists as well? Mr. Thomas, I can't see people, so I am talking to just one person, it looks like.
Your Honor, this is Dana Mills. I'm also here as a scoring panelist.
I changed my view, I figured that out. Thank you, Ms. Mills. And I can now see everybody. Are each side ready for trial here today?
Yes, Your Honor.
Yes, Your Honor, the defense is ready for trial.
Okay. And do the scoring panelists have their sheets to score?
Yes, Your Honor.
Yes.
Okay. I'll remind everybody per my script here that we will have no breaks, but if you absolutely need one, just get my attention. To the scoring panelists, I just need to check with you that you don't know any of the competitors or any of the team members, or that you don't have any relationship with them that would cause you to be biased. Ms. Radev, are you able to proceed as a scoring panelist today?
I can, but I can't see anybody either.
Go on the top right where it says view. And then
Yeah.
select the gallery view.
I don't have that.
Oh,
I did in my last version, but I don't now.
I'm not sure who to ask for help. Do we have Brian on the line? Okay, let me see if I can IM Judge Melton. And in the meantime, Ms. Mills, are you able to see the panelists? Are you available to proceed today as an unbiased panelist?
Yes, Your Honor, I am. I do not recognize anyone.
Okay. And Mr. Thomas, same question to you. Are you able to proceed today as an unbiased panelist?
I am, Your Honor. Thank you.
Let me see if we can help Ms. Radev. Am I saying your last name correctly?
Yes, you are. I don't know. It worked before, but I'm not showing any buttons for me.
Okay, let's figure this out, because you need to be able to see them to score them.
I don't have any.
I don't know if she's checking her IM or not.
This box? Yeah, I don't, it's like completely different than what I have.
Did you open it? You should maybe open it in Zoom and not through the browser.
Oh. Okay. I might have figured out the problem, which will require me to log out and log back in.
Okay, we will wait.
All right.
Oh, no. Judge Melton. No, you don't. Thank you.
Your Honor, would you like me to screen share our trial roster for you?
That would be great. Can you? Yes. I was hoping to have it in writing, but thank you. Well, I wish it would send us that. Is there a way to get that sent to us?
Your Honor, the defense just put our trial roster in the chat for you. Does that work?
It does, but
We attempted to put our trial roster in the chat last round and it did not work, but I can attempt again this round.
okay, give me just a second. So this is the defenses, right? Give me a
No,
second.
this is the prosecution.
The prosecution, okay. Leave it there for just a moment.
Here I am.
Okay, thank you.
Thank you. I do not have any conflicts.
Okay. I don't see you now.
I'm here. Can you hear
Okay, I see you. Yes, you moved to a different spot.
me?
It looks like you were demoted down my squares. Okay. And please, could the defense show me the roster as well? Are any of you?
Your Honor, I believe we posted our roster in the chat. I don't believe that we'll be able to.
In the
screen
chat.
share as well.
Got it. I understand now. Okay. Okay, I do see. Thank you. Let's go ahead and swear the team members in. You do not need to stand today because we are on video. But if you could please raise your right hands, all the team members. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Say I do if you do. You're all muted, but I can see you're all answering I do. So I will just note that for the record. To the witnesses, do I have witnesses that I can see? Okay, keep your hands up. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
Okay, I see you're nodding. Thank you. And to the scoring panelists, if you could please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Yes, Your Honor.
Okay, let's start then. Does the prosecution have any preliminary matters? And if not, are you ready to start with your opening statement?
Your Honor, may we be allowed to do our introductions?
Of course, go ahead.
Thank you. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Rachel Kidder, and I, along with my co-counsel, represent the people of the state of Colorado. I'll be giving the closing argument as well as conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen. May my co-counsel introduce themselves?
Yes, please. You're muted, Ms. Wind.
Good afternoon, Your Honor. Opposing counsel, members of the jury, my name is Claire Ann Wind, and today I will be giving the opening statement as well as conducting the direct examination of Kyle Cusack and the cross-examination of Avery Becker.
Good afternoon, Your Honor.
Go
Opposing
ahead.
counsel, Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Ivan Holtzinger, and I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins. May the people's witnesses introduce themselves.
Yes, please. Thank you.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Aubrey Pelican, and I am Kyle Cusack.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Soren DeLay, and I am Alex Cifuentes.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Angela Maley, and I am Jordan Markowitz.
Thank you all for the defense.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Ariana Elsa, and today I will be providing the opening statement for the defense, the cross-examination of Alex Cifuentes, and the direct examination of Avery Becker.
Good afternoon, Your Honor, opposing counsel and members of the jury. My name is Gavin Channel, and today I'll be giving the direct examination of Professor Blake Van Owen, as well as the cross-examination of Jordan Markowitz.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Desmond Decker, and today I will be delivering the cross-examination of Kyle Cusack, delivering the direct examination of Taylor Perkins, and I will also be delivering the defense's closing argument. Your Honor, at this time, we now request that our witnesses are allowed to also introduce themselves.
Yes, they may. Go ahead.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Marissa Ross, and today I am Avery Becker.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Hayden Lee, and today I will be Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Colby Cruiser, but today I am Blake Van Owen.
Thank you. Are we ready then to start opening statements?
Your Honor, the prosecution has some preliminary matters.
Go ahead.
First, we request, as per the rules of mock trial, that we can screen share as a way to publish exhibits to the jury.
That request is granted. Do I hear any objection from the defense?
No objection, Your Honor.
Okay, that request is granted.
Your Honor, we also request permission to publish immediately to the jury and not have to request permission every time we admit an exhibit into evidence.
Any objection to that?
No objection, Your Honor.
That request is granted.
Your Honor, we also request permission to screen share during the laying of foundation of an exhibit for the benefit of you and our opposing counsel, so you can both see what we're talking about.
Before admitting the evidence?
Yes, it will be constructively kept out of the eyes and ears of the jury.
Okay, any objection to that?
No objection, Your Honor.
That request is granted.
And finally, Your Honor, as per the rules of mock trial, we request that the clock be immediately stopped during any and all technical difficulties.
That request is granted.
Nothing further, Your Honor.
Okay, any preliminary matters from the defense?
Yes, Your Honor. The defense asks that any stipulated facts be admitted into evidence at this point in time, as well as jury instructions constructively be read to jurors.
Any objection to that?
No objection, Your Honor.
Both those requests are granted.
And we also ask that only the witness on the stand and the attorneys working with that witness have their cameras on in order to simplify things and help the scoring panelists better understand who should be scored at that time.
That request is granted.
No further preliminary matters, Your Honor.
Okay, are we then ready for opening statements?
Yes, Your Honor.
Okay, for the prosecution, go ahead.
May I begin, Your Honor?
Yes.
Motive, mischief, murder. The defendant in the case today is a woman named Avery Becker, who had a motive to retaliate against the victim, Mackenzie Brackman. The act of retaliation, to vandalize the victim's home, a crime known as criminal mischief. In the process of that mischief, the victim surprised the defendant, they struggled, and the victim, Mackenzie Brackman, was murdered. Good afternoon, members of the jury. My name is Clara Ann Wind, and today I and my co-counsel represent the people of the state of Colorado. In this trial, we are seeking justice for Mackenzie Brackman. Avery Becker had a vendetta against Mr. Brackman. They hated each other. Mr. Brackman was the coach of a mock trial team, and the defendant was the insolent team member. This relationship deteriorated so fast and so dramatically that it created a recipe for murder. This is what the evidence will show. Mackenzie Brackman was a lawyer who volunteered to help coach the Colorado high school mock trial team. The defendant was on that team, and to the defendant, that team was her entire identity. She thrived on, without preparation, dazzling the jury with her theatrical performance. The coach, on the other hand, demanded preparation and practice. These two headstrong competitors clashed continuously, with Mr. Brackman believing the defendant was arrogant and lazy, and the defendant believing Mr. Brackman was a terrible coach and lawyer. How can we know the defendant was capable of committing such a crime, members of the jury? We know this because this was not the first time something like this had happened. Just weeks earlier, the two had a series of arguments, each one building on the other. It came to a head and they blew up at one another. The defendant's reaction was disproportionate. The defendant caused extensive damage to Mr. Brackman's expensive Porsche car. Mr. Brackman caught her in the act of vandalism and in anger on the spot kicked her off the mock trial team. The defendant was determined to retaliate. How can we know this, members of the jury? We know it from the defendant's own words. First, the defendant told her mother, "I will get back at Mr. Brackman if it's the last thing I do." Second, the defendant texted a friend and said that Mr. Brackman was going to be really angry when he sees what I do to his house. I'm going to wait till he's at work, then I'm going to break in and trash it. Members of the jury, the defendant did just that. This motive of retaliation compelled her to commit criminal mischief by breaking into the Brackman home. Only something went terribly wrong. Mr. Brackman surprised the defendant. They struggled, and sadly, Mackenzie Brackman was murdered. It's not what the defendant set out to do, but under the law of this state, what the defendant did constitutes first-degree murder. Today, we will call 3 witnesses. First, Kyle Cusack, a crime scene reconstruction investigator, to testify about the evidence at the crime scene and how it supports the theory that this was criminal mischief gone wrong. Next, we will call Alex Fuentes, a former classmate and friend of the defendant's, who received the text about breaking into Mr. Brackman's home. And finally, we will call Jordan Markowitz, the lead detective on this case. She will testify about the evidence and how the cell towers placed the defendant's phone near the Brackman home at the time of the crime. The defense will also call 3 witnesses who are not going to be credible. They may try to blame this crime, on some phantom named Blair Rowlands, someone they have no evidence for and who is not even here to testify today. We believe they will first call Taylor Perkins, the best friend of the defendant, who will claim to have been with the defendant during the time of the murder. There is no evidence to support this friend's story. We believe they will also call a private investigator who is a hired gun for criminal defendants. This investigator did no real investigating and never even went to the crime scene. Finally, the defendant will take the stand. She will have to admit that she hated Mr. Brackman, that she vandalized his car, and that she promised to retaliate against him for kicking her off the mock trial team. As the prosecution, we have the burden of proving beyond a reasonable doubt that Avery Becker attempted to commit or committed second-degree burglary and first-degree murder. Because that is exactly what the evidence will show today, members of the jury, we urge you to find Ms. Becker guilty. Thank you.
Thank you, Ms. Wind. For the defense, please.
Yes, Your Honor. Framed evidence, faulty police work, and the fallacy that is this trial. Today, the prosecution will try to argue that Avery Becker murdered her mock trial coach because she did not like how her coach, Mr. Brackman, treated her. They will argue that Avery Becker, a high school student, killed a man because of an extracurricular activity. We will prove that this is a ridiculous notion. My name is Ariana Elsa, and my colleagues and I will demonstrate that Avery Becker could not and would not kill her mock trial coach. Avery Becker simply wanted to be a respected member of the mock trial team. She loves lawyering and has a natural affinity for it. She will share with you that the notion that she would kill Mr. Brackman is a fallacy. She will testify to her alibi, that she was with friends at the time of Mr. Brackman's death. Most importantly, She will testify that her differences with Mr. Brackman within my trial did not bring her to kill him. Furthermore, Taylor Perkins, a friend of Avery Becker, will testify to Avery's character. He will also testify that Avery was with him the entirety of the day that Mr. Brackman died. He will also testify about other possible suspects that had the means to alter evidence and the perspective of the police, like Alex Cifuentes. He will testify that Avery Becker was framed. Blake Van Owens will testify that the police work of Kyle Cusack and Detective Markowitz, two of the prosecution's witnesses, was unsatisfactory. They were rushed and missed many important facts of the case, such as details on the knife, specifics about the Ring doorbell, and many other pieces of evidence in this case that the prosecution has completely built their case on. The police work that the prosecution will present to you today via Kyle Cusack and Detective Markowitz was faulty. The defense will also present to you 3 witnesses today. Kyle Cusack and Detective Markowitz are 2 of them. As they present, please consider their lack of respective education and training and how they jump to conclusions without the complete evidence. They will also present to you Alex Cifuentes. Please consider their bias and their own motives in this case. If you have any reasonable doubt today that Avery Becker murdered his mock trial coach, you must find her not guilty. The prosecution today has the burden of proof, and we will show to you that Avery Becker was framed, the police work was faulty, and this entire trial is a fallacy. Avery Becker did not kill his mock trial coach.
Thank you. Is the prosecution ready to call their first witness? Ms. Wynn, you're muted.
Sorry about that. The prosecution calls Kyle Cusack.
Ms. Cusack, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Kyle Cusack. That's K-U-Z-A-K.
Ms. Cusack, what is your profession?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator, but that's a mouthful, so we just use the term CSR.
As a CSR, will you tell the jury what you do?
Absolutely. I investigate complex crime scenes, including home invasions, burglaries, and other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
How many years of experience do you have as a CSR?
I have 19 years of experience.
What have you been doing in your most recent years?
For the last 3 years, I have been a civilian employee for the city of Denver. That means I am not a certified peace officer.
In the case today, the defendant is being charged with second-degree burglary and first-degree murder. Do you have any experience investigating those types of crimes?
Yes, that is exactly what I do for a living.
Please tell the jury how you investigate and reconstruct crime scenes.
Well, I've actually developed a 5-step process for the purpose of reconstruction and investigation of crime scenes. Those steps involve identifying evidence, collecting evidence, evaluating evidence, creating a hypothesis based on that evidence, and reconstructing the crime scene.
You seem to be very intentional in your investigations. Why is that?
Well, I assume from day one that any crime I investigate will go to court at some point, and for that reason, I'm extremely thorough in all my investigations.
Did you use your process to investigate the crimes we are discussing today?
Absolutely.
Your Honor, the people of the state of Colorado offer Kyle Cusack as an expert witness in crime scene reconstruction and investigation.
Any objection?
Yes, Your Honor. Permission to perform a brief voir dire.
Permission granted. Go ahead.
Thank you. Mrs. Cusack, it is true that you are not a police officer.
No, I'm not a police officer. I'm a crime scene reconstruction investigator.
You're merely a civilian employee of the City of Denver Police Department, correct?
Yes, that is true.
And it is true that you were not at the scene of the murder until far after it was processed?
I went to the scene after it had been processed by the crime lab. It was not far after.
Thank you. And much of the evidence you mentioned in your report has mysteriously disappeared.
I'm sorry, I don't know what you mean by that. Some of the photos were corrupted, but otherwise, I have everything.
So yes, much of your evidence has disappeared. Thank you. Your Honor,
No, I didn't say
the
that.
defense objects to the admission of Mrs. Kyle Cusack as an expert witness, as she lacks the knowledge of the case, as much of her evidence has disappeared. And in addition, she lacks the experience, as she is not a police officer and she wasn't at the scene of the processing of the crime scene.
Your Honor.
Yes, you may respond.
Your Honor, under the Federal Evidence Rules 702, an expert witness can be qualified by knowledge, skill, experience, training, or education. Ms. Cusack not only has the skill, experience, and training, but she does have quite a bit of knowledge and experience that would qualify her to be received into court as an expert witness in crime scene reconstruction and investigation, as she has had so much knowledge and training in those areas. What the police did or did not do does not have anything to do with her qualifications.
Thank you. The court overrules the objection and will permit Ms. Cusack to testify as an expert.
Yes, Your Honor. Ms. Cusack, how did you become involved in this investigation?
I was called to investigate a homicide at 444 South Flower Street in the city and county of Denver, state of Colorado, on March 6th of 2020.
Who was the victim?
The victim was Mackenzie Brackman.
Turning to your 5 steps, how did you identify evidence here?
I created a witness tracking spreadsheet and a physical evidence tracking spreadsheet.
Please turn to Exhibit 17. What is that?
Exhibit 17 are my spreadsheets.
How do you know?
I personally created Exhibit 17.
Is Exhibit 17 a fair and accurate copy of the document that you created?
Absolutely.
The people of the state of Colorado offer Exhibit 17 into evidence.
Any objection?
Yes, Your Honor. Pursuant to Rule 801, this is hearsay.
The objection is overruled. Exhibit 17 is admitted.
Now, Ms. Cusack, the defense alleged in their opening statement that you limited your investigation to Avery Becker. Is that true?
Absolutely not. As Exhibit 17 shows, I looked at 3 suspects. The primary suspect was Avery Becker, the secondary was Alex Cifuentes, and the tertiary was Blair Rollins.
Why did you ultimately focus on Avery Becker?
After the department's investigation, it was clear to them that Avery Becker committed this crime. There was absolutely no evidence whatsoever that anyone else was involved.
All right, Ms. Cusack, turning to your 5 steps, how did you collect evidence here?
I went to the crime scene after it had been processed by the crime lab. I collected the police reports, photographs, several videos from the ring security cameras, and the copy of the official autopsy report.
You said you went to the crime scene. What did you find there?
I observed the ring doorbells and their video footage. I observed scuff marks near the back door. There was an open drawer with several knives in it, a knife block with an empty slot in it, perfect for a chef's knife. There was also a broken plate near the table, and then in the hallway leading to the front door, there were blood droplets, and by the front door, there was a large pool of blood and a bloody chef's knife.
Let's move on to your evaluation of evidence, starting with the ring videos. What did you do?
I watched the videos.
Please turn to Exhibits 10 through 13. What are they?
They are the ring videos.
You know.
I was there. I saw the ring videos. The videos come from the places that those cameras were placed, and I received these videos from Detective Markowitz.
Are Exhibits 10 through 13 fair and accurate depictions of the videos that you received from Detective Markowitz?
Yes, they are.
Honor, the people of the state of Colorado offer Exhibits 10 through 13 into evidence.
Any objection, Mr. Decker?
Yes, Your Honor. We don't believe that prosecution has laid enough foundation. We don't know when these videos were from. They could have been from years ago.
The objection is overruled. Exhibits 10 to 13 are admitted.
For the sake of time, Ms. Cusack, will you just discuss Exhibit 11 for the jury?
Absolutely. This shows the perpetrator, about the defendant's height and build, entering through the back gate. They're wearing a Halloween mask and gloves.
Thank you. Let's take a step back and talk about the victim for a minute. How did Mr. Brackman die?
He was stabbed. Specifically, a knife penetrated his aorta, and when it was removed, he bled out and died.
Please tell the jury about steps 4 and 5 of your process, testing your hypothesis and then reconstructing the crime scene.
After I completed my investigation, I reviewed all my work, analyzed it, and reconstructed the crime scene.
And what did your reconstruction show?
The evidence clearly pointed to a home intruder, most likely a burglar, who entered the residence and, not expecting Mr. Brackman to be home, was caught off guard. Mr. Brackman, who had a knife as evidenced by the empty slot in the knife block, surprised the invader, and as the scuff marks and broken plate show, there were clear signs of a scuffle in the kitchen, leading me to conclude that the ensuing struggle resulted in Brackman being stabbed.
Objection, Your Honor. This is to the knife in the knife block. We're assuming facts not in evidence here. The knife depicted, we have no idea whether or not it actually came from the knife block. In fact, if you look at the exhibit, it does not match the set.
Response, Your Honor?
Yes, go ahead.
Your Honor, this witness was just about to testify that if you allow me to continue my questioning just a little bit farther, it will become clear.
The objection is overruled pending Ms. Wynn's supplement of the testimony.
Yes, Your Honor. Ms. Cusack, you just testified that Mr. Brackman had a knife with him. What about the intruder? Did they have a knife with them when they entered?
Although it is possible, the video showed no evidence that the intruder had a knife on them. It would have been extremely difficult to carry that large of a knife and baggy sweatpants. I believe the knife came from Mr. Brackman's knife block.
And why do you believe that?
When I analyzed the crime scene, there was only one knife missing from the knife block, and it happened to be of the right shape and size to store the chef's knife that was used to commit the murder.
Was the knife of the same brand as the rest of the block?
No, that knife was not. The knives in the knife block were from a more expensive set.
Did that concern you?
Certainly not. It is reasonable for a person to replace a chef's knife if, for instance, the original knife had been lost or damaged. Mr. Brackman could have easily replaced it with a similar knife.
Finally, Ms. Cusack, is it your job with the Denver Police Department to determine who committed a crime?
No, my job is to investigate and reconstruct crime scenes so that the detectives can find the right person.
And through your reconstruction, did you reach any conclusions?
Yes, I certainly did.
For expert opinion, what happened at 444 South Flower Street on March 6, 2020?
This was clearly a planned break-in gone bad. The intruder had knowledge of the victim's property and likely chose a time of day when the victim's patterns would have placed him outside the home. Either the Ring doorbell alerted Mr. Brackman of the intruder's presence, or he saw the intruder directly, and Mr. Brackman grabbed a knife in order to defend himself, and his own death resulted.
Did your investigation show anything about whether this was a premeditated murder?
All the evidence suggests that the intruder did not originally intend to kill Mr. Brackman, but Mr. Brackman's surprise presence in his home, his awareness of the intruder, and his attempt to defend himself altered those circumstances.
Thank you. I have no further questions at this time, Your Honor.
Okay. Cross-examination, Mr. Decker.
Thank you, Your Honor. Mrs. Cusack, you visited the scene after it was processed, correct?
Yes, I've already said that.
And in your report, you organize and account for evidence that you acknowledge had potential fallibility.
I'm sorry, I don't understand what you mean by that.
You acknowledge that much of the evidence used to make your conclusion had potential fallibility. Is this true?
Potential, yes.
Thank you. And it is true that several of the digital photographs of the scene have been corrupted.
Yes, they have been.
These photographs and cast-off were lost after
Objection, Your Honor, relevance.
What is the relevance, Mr. Decker?
Your Honor, the presence of evidence that she makes her claim off of is incredibly relevant in this case, as it determines who is guilty and who is not. And if she's making her claims based off of evidence that we cannot see, we cannot trust that that evidence has anything. We can't trust that it exists or proves anything.
Response, Your Honor?
Yes, please.
First of all, the things that the co-counsel is asking Ms. Cusack to testify about not only do not have anything to do with her, as she was not the one responsible for the losing or the corruption of the photos, but they are also extremely not relevant because they do not have any impact on Ms. Cusack's opinions in this case. They are simply photographs of some blood spatter. They have nothing to do with any theories or opinions that she has proposited today, and as such, they are completely irrelevant to the testimony.
The objection is overruled. Ms. Cusack can answer the question, however, based on whatever knowledge she has of the evidence.
Thank you. Mrs. Cusack, I will ask the question once more.
Thank
the
you.
Photographs of the blood were mysteriously lost after that you had made your analysis of the crime.
They were partially corrupted, but I have a perfect recollection of what they looked like.
but we don't. So your in-depth analysis was conducted after the relationships were documented during your organization process, where much of this evidence disappeared.
It was only a few photographs of the blood splatter.
Thank you. Your conclusions found that the perpetrator matched the general height and build of the defendant.
Yes.
And what data allowed you to make such a specific conclusion? We don't know the race or the gender.
Well, obviously we don't know that because we couldn't see the person. They had a Halloween mask and gloves on, very baggy clothing, but we can reference the height of the fence to the height of the perpetrator, and it matches Avery Becker's description.
So the only data allowing you to make this connection is a very general estimate of height.
I guess you could say that.
And there was no DNA evidence found at the scene.
Well, obviously not. They had gloves on.
You admit that many of Van Owen's conclusions fall outside the area of your expertise.
Well, yes, I am a crime scene reconstruction investigator, and Van Owen is not, so...
And Blake Van Owens is a certified police officer.
Objection, Your Honor, beyond the scope of the witness's statement.
May I respond, Your Honor?
I'll sustain the objection on other grounds. Was that a question, Mr. Decker, or a statement?
Your Honor, I believe it was a leading question, as it is called for.
Okay, go ahead, Mr. Decker.
Okay. I will ask the question again. It is true that Blake Van Owens is a police officer, correct?
Objection, Your Honor, lack of foundation.
Your Honor, if I may respond, the witness that is currently testifying has supposedly overlooked this entire case and would know perfectly well whether or not Blake Van Owens was in fact a police officer.
The objection is overruled. The witness can testify whatever she knows in regard to this question. Go ahead, Mr. Decker.
Thank you, Your Honor. Mrs. Cusack, I'll ask this one more time. You know that Blake Van Owens was in fact a police officer.
Blake Van Owen is a professor currently. They used to be a police officer.
Thank you. And so far as all of your evidence is concerned, you were not able to recreate all the event segments or place all the evidence that was at the crime scene.
I was not, unfortunately, but I wasn't there when the crime happened, so I couldn't have done that.
And you would prefer that you had more physical evidence at the scene?
I would always prefer to have more physical evidence at any crime scene.
There was an absence of evidence where your conclusions suggested that there might be.
I'm slightly confused. What do you mean by that?
You suggest in your statement that there was an absence of evidence where there should have been evidence to support your conclusions.
Yes, I do.
Thank you. And though you disagree with Blake Van Owen's idea that the intruder snuck up, you admit once again that his conclusions are outside the area of your expertise.
That conclusion specifically is not.
You state that this type of conclusion was made by looking only for evidence that you can arguably support Van Owen's predetermined conclusion.
Yes, I think I understand what you mean by that.
Thank you. And it is not your job to establish who the murderer was, correct?
No, that is not my job.
It is the detective's job, yes?
Yes.
And some of the detectives present do not agree that Avery Becker was the murderer.
Who are you referring to?
What is the objection, Ms. Wind?
This witness is being asked to testify about statements that are not in her witness statement, but rather in another witness's statement. This is clearly something she should not answer.
Your Honor, if I may respond.
Go ahead, Mr. Decker.
Thank you. I'm not asking Mrs. Cusack to testify about another witness's statement, merely that another one of the detectives is here testifying today that Avery Becker is not the one that murdered Coach Brackman.
The objection is sustained. Ms. Cusack will not be able to observe the other witness testify or comment on it. Next question, Mr. Decker.
Your Honor, we have no further questions at this time.
Okay. Ms. Wynn, do you have any redirect?
Yes, Your Honor.
Go ahead.
Ms. Cusack, in your job, do you base your conclusions on facts or on theories?
I base my conclusions on solid facts.
Do you examine all the evidence in making your conclusions?
Yes, I do.
Thank you. No further questions, Your Honor.
Do we have any recross, Mr. Decker?
Shortly, Your Honor.
Objection, Your
Cusack.
Honor. Your Honor, objection. Under the rules of mock trial, we are not allowed recross.
Okay, my sheet somehow says redirect and recross, so we will move on. Mr. Decker, is that your understanding? No recross?
Your Honor, it is depending on the case. We have had mock trial cases where we've been allowed to recross and others which are infrequent where we have not.
Okay, thank you. Let's go to the next witness.
Your Honor, the people of the state of Colorado call Alex Cifuentes.
Good afternoon, Mr. Cifuentes.
Good afternoon.
Let me swear you in. Could you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, Mr. Holtzinger.
Good afternoon. Please introduce yourself to the jury.
My name is Alex Cifuentes, and Cifuentes is spelled Sifuentes.
Do you know the defendant?
Yeah, Avery and I have been best friends for years.
Your Honor, the people request that the defendant briefly turns on their screen for the purposes of an identification.
That is so ordered. Defendant. Can the defendant turn on your camera, please, so that Mr. Cifuentes can see you?
Mr. Cifuentes, do you see the defendant on your screen?
Yes, I do.
Okay.
What color is her hair?
I believe it is blonde.
Your Honor, let the record reflect Mr. Cifuentes has identified the defendant as Ms. Becker.
The record will so reflect.
We also ask at this time that Ms. Becker turns off her screen.
It is so ordered.
Mr. Cifuentes, where did you spend the most time with the defendant?
We were both on the Colorado High School mock trial team.
Why did you join the team?
It was actually Avery who convinced me to try it out in the first place, and it sounded super cool.
As you know, the defendant is on trial for the murder of Mackenzie Brackman. Did you have any opportunity to witness the defendant and Mr. Brackman interacting with each other?
All the time.
In what context did you see them interacting?
At our mock trial practices and competitions.
How would you describe their relationship?
It was terrible. They were always really frustrated with each other and for sure hated each other.
Objection. This is speculation. The witness does not know exactly how the defendant and the deceased felt about each other.
Okay, Mr. Holtzinger responds.
Your Honor, opposing counsels waive this objection by allowing this testimony to come in.
The objection is overruled. You may continue.
Mr. Cifuentes, let me repeat the question. How would you describe the relationship between the defendant and Mr. Brackman?
It was not very good. They were always really frustrated with each other and hated each other.
Did you ever see any actual conflict between the two of them?
Yes. One day when Avery was late for practice, again, Mr. Brackman got big mad.
What happened after Mr. Brackman got so mad?
This is still speculation. The witness can speak to what he observed, but he does not know Mr. Brackman's feelings, and Mr. Brackman is not here to testify about those.
Your Honor, once more, opposing counsels waive their objection by allowing the testimony to come in.
When did the testimony come in?
It came in right before they objected to speculation.
I can't remember, and it may be my fault, that testimony coming in prior to now. So I'm going to have to sustain Ms. Elsie's objection. Please continue.
Mr. Cifuentes, did you ever observe any actual conflict between Mr. Brackman and the defendant?
Yes. One day, when Avery was late for practice, again, Mr. Brackman got big mad.
What happened after Mr. Brackman got so angry?
Objection. The witness has testified to the same, that Mr. Brackman was mad. He does not know this. Can this please be stricken from the record?
The objection
Your Honor,
yes,
if
go
I'm
ahead.
maybe allowed to respond, under Rule 701, this is an opinion testimony by a lay witness. Mr. Cifuentes is rationally basing this comment off of his own perception. It is helpful to clearly understanding his testimony or to determining a fact and issue, in this case, Mr. Brackman's feelings toward the defendant, and it is not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. So therefore, under Rule 701, this is not speculation on Mr. Cifuentes' part.
I'm going to overrule the objection. I think it would help if Mr. Cifuentes would say, they appear to be mad, or it was my observation, so that it is clear that it is his opinion, okay?
Mr. Cifuentes, let me continue. What happened after Mr. Brackman got so mad?
He demoted Avery to the B team.
What happened after the defendant got demoted?
Taylor Perkins, who was good friends with Avery, quit the team. That forced Mr. Brackman to put Avery back on the A team.
How did the team do after that?
At regionals, we advanced to state. Avery won Best Attorney and Best Closing Argument awards.
Did these awards make things better between the defendant and Mr. Brackman that you perceived?
No way. Just the opposite. At the next practice, Mr. Brackman was super critical of Avery for not preparing.
Did Mr. Brackman's comments have any impact on the defendant that you perceived?
Yeah, Avery got super pissed and left practice.
What happened after the defendant got so mad?
I saw Avery grab a permanent marker on the way out, which seemed kind of weird.
What happened after the defendant grabbed a permanent marker?
Mr. Brackman had a dope car, a 1986 Porsche 911, and Avery wrote Worst Attorney Award and permanent marker on it.
What happened after this act of vandalism?
Mr. Brackman kicked Avery off the team completely.
How did the defendant react to being kicked off the team to your perception?
Avery texted me shortly after she was off the team and asked if I would talk to Mr. Brackman about having her back on the team.
Did you talk to Mr. Brackman about that?
Yes, I went to Mr. Brackman and pleaded with him to let Avery back on the team.
Did Mr. Brackman let the defendant back on the team?
No, he refused to.
Objection. This is hearsay.
Your Honor, Mr. Brackman, are you objecting to Mr. Cifuentes' comments or Mr. Brackman's comments?
Mr. Brackman's comments.
Your Honor, Mr. Brackman's comments are not being offered for the truth of the matter, but for the effect they had on the listener, in this case, Mr. Cifuentes. Mr. Brackman's comments prompted Mr. Cifuentes to text the defendant back, which caused her to have an outburst, which we believe goes to her motive for committing this crime, and is therefore an exception to hearsay.
The objection is overruled.
Mr. Cifuentes, let me repeat the question. Did Mr. Brackman let the defendant back on the team?
No, he refused to.
After the vandalism incident and the defendant being kicked off the team, did you contact the defendant in any way?
Yes, by texting.
Please turn to what has been marked as Exhibit 14.
Okay.
What is it?
It is a text conversation between me and Avery.
How do you know?
I was the one who captured these screenshots.
Is this a fair and accurate copy of the screenshots you captured of your conversation with the defendant?
Yes, it is.
How do you know it was the defendant who was texting you and not someone else?
Well, we have texted many, many times. Her number was saved into my phone, and we were talking about things personal to her that only she would know.
We believe that the defense is going to ask whether these text messages were doctored or manipulated in any way. Did you doctor or manipulate these screenshots in any way?
No way. I don't even know how to do that.
Your Honor, the people of the state of Colorado offer Exhibit 14 into evidence.
Objection. Yes, Your Honor. I object to this evidence on the grounds of hearsay. Alex Cifuentes' statements in this text chain are hearsay.
What is your response, Mr. Holzinger?
Your Honor, Mr. Cifuentes' comments are not hearsay because they are not going to the truth of the matter before the effect they had on the listener, in this case, Mr. Becker. These statements go directly to Ms. Becker's motive for committing the crime because his comments are her only communication with Mr. Brackman and prompted her to attempt to break into Mr. Brackman's house. These go directly to the prosecution's theory as to why the defendant committed this crime and therefore are not being offered for the truth of the matter and are not hearsay.
The objection is overruled. Exhibit 14 is admitted.
Mr. Cifuentes, in what color are your comments on the screen?
They are green.
How did you respond when the defendant asked whether you talked to Mr. Brackman about letting the defendant back on the team?
I guess I could try, but after the car situation, I doubt anyone could change his mind.
Objection. This evidence was admitted under the rules that it would not be used to prove what Alex actually said, just for context, and he is directly reading off what he wrote, indicating that he is using it for the truth of the matter.
Response.
Your Honor, once an exhibit is admitted into evidence, it may be used however we see fit, as long as it's relevant, and this is relevant testimony, and so therefore this is not misuse of a exhibit already admitted into evidence, and is not hearsay.
That's right. The exhibit is already admitted into evidence, so they can publish and comment on it as they see fit.
Let me repeat the question, Mr. Cifuentes. How did you respond when the defendant asked you to talk to Mr. Brackman?
I guess I could try, but after the car situation, I doubt anyone could change his mind.
How did the defendant respond to that?
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
How did you respond to that?
I was kind of confused, so I texted her back and asked what that meant.
Did she tell you what that meant?
Yes, she said, I'm going to wait until he's at work, then break in and trash it. That'll show him.
Mr. Cifuentes, how did you become aware of Mr. Brackman's murder?
Some detective called me about it.
What did the detective want?
The detective wanted to talk with me and also wanted screenshots of the text conversation.
This is hearsay to the detective's conversation.
Your Honor, no statement is being offered in this case. Mr. Cifuentes is merely stating a fact that that Detective Markowitz talked to Mr. Cifuentes, so no comment is actually being asserted. There is no statement here, so it's not hearsay.
The objection is overruled. You may continue.
Let me repeat the question. What did the detective want?
The detective wanted to talk with me and also wanted screenshots of the text conversation between me and Avery.
What did you do after talking to the detective?
I had the screenshots on my phone and I emailed them to the detective.
Did you also talk to anyone who worked with Avery?
Yeah, Avery had some sort of weird private investigator who tried to talk to me. I didn't want to, but she insisted.
How did that conversation go?
Oh, it was just awful. She tried to get me to lie. She wanted me to say that I faked the text messages to Avery, which I
object on grounds of both hearsay and speculation.
Response.
Your Honor, I don't understand the speculation objection because Mr. Cifuentes is commenting on a conversation that he had with a detective. So I don't see how he's speculating on any grounds. As to hearsay, Mr. Cifuentes is simply, Mr. Cifuentes is trying to prove Detective Blake Van Owen's character under 405A. Character may be proven by reputation or opinion. This is not being offered for the truth of the matter, but for the effect it had on the listener, in this case, Detective Blake Van Owen, and it will go to her character. Under Rule 611, I believe. Yeah, under Rule 611, mode and order of examining witnesses and presenting evidence, the court controls the order of presenting witnesses. After Detective Van Owen is on the stand, Mr. Cifuentes won't be able to testify as to her character, so we ask that he may testify about her character now.
I will allow it. The objection is overruled.
Let me repeat the question. How did your conversation with Detective Van Owen go?
It was just awful. She tried to get me to lie. She wanted me to say that I faked the text messages to Avery, which I obviously didn't.
We believe that we will hear that someone stole the defendant's phone. Did you steal the defendant's phone?
No way. Why in the world did I do that?
Finally, did the defendant have a reputation among the mock trial team?
Oh, yes, she did.
What was that reputation?
Avery had a reputation for laziness, always being late and never coming prepared for practice or the tournaments. She also had a reputation to do this
Objection.
crazy thing.
Improper character evidence.
Your Honor, this is not improper character evidence because this testimony is going to going to the defendant's character, and character is admissible under Rule 405A. This is not improper character evidence. Therefore, we ask that Mr. Cifuentes is allowed to testify about her character.
And I think you said it was reputation evidence, so I will allow it.
Let me repeat the question, Mr. Cifuentes. Did the defendant have a reputation among the mock trial team?
Oh, yes, she did.
What was that reputation?
Avery had a reputation for laziness, always being late and never coming prepared for practice or the tournaments. She also had a reputation to do this crazy thing as a witness where she made things up and convinced the judge and jury that it was completely true.
Thank you, Mr. Cifuentes. No further questions, Your Honor.
Okay, cross-examination, Ms. Elsie.
Yes, Your Honor, thank you. You think Avery Becker refused to work hard, correct?
Yes, she did not work very hard.
Is it true that Avery Becker had more success at mock trial competitions than you?
Objection relevance.
What is the relevance?
The relevance of this is trying to establish the relationship between Avery Becker and Mr. Alex Cifuentes.
Response.
Could you repeat that? I'm sorry. Someone has their mic unmuted, so I couldn't hear what you said.
Yeah, I can hear somebody whispering, so I think somebody might inadvertently have turned on their mics.
Will you repeat your justification?
My response was that this goes to the relationship between Alex Cifuentes and Mr. Avery Becker, which is something you covered in your cross-examination.
Your Honor, I hardly see the relevance in whether or not the defendant was a better mock trial competitor or not. This doesn't go to the relationship. It merely goes to skill in mock trial. So I don't see how this is relevant.
The objection is overruled. I will allow it. It also shows bias. Go ahead, Ms. Elsie.
Is it true that Avery Becker had more success at mock trial competitions than you?
Well, she did win Best Attorney and Best Closing Argument awards.
Did this upset you?
Yes, because Avery kind of won them for all the wrong reasons.
You also accused Avery Becker of having no real talent, correct?
She mostly just won them off looks.
Avery asked you to help her get back on the team again, correct?
Yes.
She wanted to make amends.
Yes.
Yet you did not want her back on the team.
I didn't really think it would be good for our team, but I did go to Mr. Brackman and plead with him to let Avery back on the team.
And you would get a larger role if she were left off the team, correct?
Most likely. I'm not for sure though.
You were excited that Avery Becker was off the team because you would ultimately benefit, correct?
Well, I wasn't excited for my best friend to be off the team, but I was excited for the larger roles.
And you allege that Avery Becker texted you about breaking into Mr. Brackman's house?
Yeah, she did text me.
Yet all you have are screenshots.
Yeah. I mean,
the police. Sorry?
Yes, that's all we have. I believe so.
The police never demanded to look at the actual texts?
They saw the screenshots.
And it's convenient that you no longer have the actual phone, correct?
I got rid of it a few months ago because it was super old.
You did see Avery at the Fry Shack a day prior to Mr. Brackman's death and the day that Avery's phone went missing, correct?
Yeah, we always go to the Fry Shack after mock trial practices.
And did you have relationships with Blair Rollins, my apologies, another suspect in this case?
No, not at all. Like, we might have said hi to each other through the halls, but that would be about it.
Did you say hi and goodbye regularly?
Objection hearsay.
Response.
This is going to a regular practice of the witness. He would know if he regularly saw and spoke with Blair Rollins. It's not going to the truth of the matter.
The objection is overruled.
Would you repeat that, please?
Yes. Did you regularly say hello and goodbye to Blair Rollins?
Yeah, it kind of just depended on the day, you know?
And you and Avery Becker are no longer friends, correct?
I would still say we're friends.
Even after you accused her of murder, you're still friends?
Objection
Yeah.
hearsay.
What is the hearsay, Mr. Holsinger?
She's asking about a statement that Mr. Cifuentes accused the defendant of murder, and that is an out-of-court statement being offered for the truth of the matter.
May I respond?
Yes, you may.
The whole testimony of Alex Cifuentes was him accusing Avery Becker of murder, so I do not think that is an out-of-court statement.
The objection is overruled. Mr. Cifuentes is on the stand subject to cross-examination, so you can ask him the question, Ms. Elsie.
Thank you. Are you and Avery Becker still friends even though you accused her of murder?
Yes.
No further questions at this time.
Any redirect, Mr. Holsinger?
Yes, Your Honor. Briefly, Mr. Cifuentes, does Avery's getting better roles on the mock trial team impact your testimony in any way today?
No.
Did the police ever ask for the actual cell phone, or were the screenshots?
Objection, hearsay.
What is the hearsay, Ms. Elsie?
He's asking about what police officers may or may not have said. Under
Your
Rule
Honor-
8.
Your Honor,
Okay.
I believe opposing counsel asked this exact same question. I'm only asking whether or not the police required Mr. Cifuentes to give them any more than the screenshots that he gave them. This isn't technically an actual statement being offered for the truth of the matter.
That's right. The objection is overruled.
Mr. Cifuentes, did the police ask for anything other than the screenshots?
Nope.
No more questions, Your Honor.
Thank you. Next witness, please.
The state of Colorado call Detective Jordan Markowitz to the stand.
Detective Markowitz, let me swear you in. If you could please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, yes.
May I proceed, Your Honor?
Yes.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Jordan Markowitz, and my last name is spelled Markowitz.
Ms. Markowitz, what do you do for a living?
I'm a homicide detective with the Denver Police Department.
How long have you been with the Denver Police Department?
Oh, let's see. I've worked in the police department for 13 years, and I've been a detective for 7.
Let's talk about some of your qualifications. Besides all the training and certification that you received as a police officer, do you have any specialized training that you use in your detective work?
Yes, in fact, I have specialized training and certification with cell phones.
Please describe that.
I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What were the requirements for you to receive this certification?
Well, I had to complete a 3-day training course as well as pass a certification test where I learned about different types of cell phone data, records, and how to use forensic software. I also had to learn to download the contents of a cell phone as well as how to interpret, and inquire cellular data and records.
How often do you use that training?
Constantly. In this day and age, cell phones are a crucial part of any investigation I conduct. I've downloaded the contents of hundreds of cell phones, and I've obtained and interpreted cell tower data in over 50 cases, I'd say.
Your Honor, the people of the state of Colorado offer Detective Jordan Markowitz as an expert witness in the field of criminal investigation with a subspecialty in cell phone technology.
Any objection?
Yes, Your Honor, permission to conduct a voir dire as well.
You may.
Detective Markowitz, you recently lost evidence as a part of an investigation that you were the head detective of. Is that right?
The evidence became corrupted.
And you claim that your specialty is in cell phones. Is that correct?
Yes, that is correct. I have specialized training and certification for that.
Yet your only training in cell phones was merely a 3-day course?
Well, that's all that it took for me to learn everything I needed.
And despite your time in the Denver Police Department, you've never testified in court as an expert before, have you?
No.
Your Honor, I object to the admission of this witness as an expert on account of their lack of skill and experience. Despite their time, they lack the knowledge and experience to properly investigate and then discuss a case like the one today.
The objection is overruled. Detective Markowitz will be permitted to testify as an expert. Go ahead.
Detective Markowitz, did you have any involvement with this case today?
Yes, ma'am. I was the lead detective on the case of Mackenzie Brackman's murder.
Will you please tell the jury how the case even began?
Of course. So on Friday, March 6, 2020, we got a call about someone who had appeared to be passed out on their front porch. We sent some medics down to see what was going on, but upon arriving, they found the victim was actually dead. That's when I was called to the scene of the crime, and I arrived around 2:20 p.m.
When you arrived, what did you notice?
I saw that the front door was wide open, as well as the victim was lying face down just inside the house in a pool of his own blood. There was also blood spatter on the walls, as well as a large bloody knife on the floor just past the victim's body.
Detective Markowitz, please turn to what have been marked as Exhibits 1 and 3, and my co-counsel should publish it, or not publish, share those on the screen. Do you recognize these exhibits?
Yes, ma'am, I do.
What are they?
These exhibits are pictures of the victim's body.
How do you know?
Because I observed this body at the crime scene I was sent to investigate on March 6, 2020.
Are Exhibits 1 and 3 fair and accurate depictions of the victim's body in the home on March 6, 2020?
Yes, they are.
Your Honor, the people of the state of Colorado offer Exhibits 1 and 3 into evidence.
Any objection?
Yes, Your Honor, I believe these two exhibits are cumulative and only one is needed. The second one offers no information that's not clear in the first exhibit.
The objection is overruled. Exhibits 1 and 3 are admitted.
Detective Markowitz, please describe these exhibits to the jury, beginning with Exhibit 3.
Well, as you can see here, Exhibit 3 is a close-up of the victim's back and the stab wound. And Exhibit 1 is a photo of the victim's body as viewed from the front porch. You can also see a Ring doorbell in the top right portion of the picture.
If co-counsel could please switch to Exhibit 1. Thank you. Detective Markowitz, were you able to recover anything from this Ring doorbell?
As you saw during Investigator Cusack's testimony, we were able to recover Ring videos because Brackman had paid extra to keep the security footage. But I'm not going to go into those because she's already discussed those videos.
Co-counsel can stop screen sharing now. What did you do after assessing the front of the house?
I went around to the back of the house where I observed 2 Ring security cameras. There was one facing the fence and the other was facing the back door. Then I went to the kitchen.
What did you see in the kitchen?
There were scuff marks by the back door indicating there could have been a struggle, as well as an open knife drawer and a knife block on the counter with one knife missing. By the table, there was an overturned chair, a broken plate, and drops of blood on the floor, and you could also tell that nothing was missing from the household.
Based on all of the evidence you collected, were you able to form a theory as to what happened in the home that day?
Yes, Mr. Brackman came upon an intruder breaking into the house and confronted them with a large knife. The intruder gained control of the knife, stabbed the victim, and ran out the front door.
Please tell the jury the factual basis for that theory.
Well, the videos had made it look like Brackman had just interrupted a random burglary. The intruder also entered the house at a time of day that Brackman would have usually been at work. The knife drawer open, as well as the knife block on the counter with one knife missing, also indicate that the victim armed himself.
Now let's talk about the rest of the investigation you conducted. What was the first thing you did after assessing the entire crime scene?
I began downloading the contents of Mr. Brackman's phone.
Did you find anything of significance?
I found a tremendous number of texts and emails related to mock trial, which is how I found out that Brackman was a coach for Colorado High School's mock trial team. I then reached out to the school to get contact information for all the students on the team, called one of them, and that's when I got my biggest break in the case.
Who was the student you called?
Alex Cifuentes.
Did you meet with Alex Cifuentes?
Yes, and he showed me the text messages that we saw in Exhibit 14.
Let's pull those up for a moment. Detective Markowitz, what specifically about these text messages did you classify as the biggest break in the case?
Well, as you can see, the defendant basically confessed that it was her intent to break in and trash Brackman's house, which is exactly what happened.
Did you obtain this phone from Alex Cifuentes?
No, I had asked to see it, but he forgot to bring it with him to the interview.
We are most likely going to hear a theory from the prosecution that these messages were doctored in some way. What is your response to that?
Well, with all of my experience as a detective, I would be able to tell if evidence was doctored, and there's no evidence to support that theory.
What did you do after seeing these screenshots?
I turned the focus of the investigation onto the defendant. Upon doing so, I learned she was recently kicked off the mock trial team for vandalizing Brackman's car.
Did you ever personally speak with Ms. Becker?
I tried, but ultimately I was unable to.
What did you do then?
I got a warrant to search Becker's phone, but when I called to make arrangements to search the phone, I found Becker claimed she lost the phone the day before the crime. But I did get the phone number.
Once you got Ms. Becker's phone number, what did you do with it?
I obtained a court order to get account records from Becker's service provider. Then I received these records as well as the call detail records. These records indicate when and where a cell phone reaches out to a cell tower to send or receive a text or call. With these records, I was able to see the cell towers that the defendant's phone was connecting to receive texts and calls, as well as the duration of those calls.
Based on all of the evidence you collected at the conclusion of your investigation, were you able to form a conclusion as to the defendant's movements on March 6, 2020?
Yes, the defendant was at home somewhere between 12:45 and 12:50 p.m., then left and drove towards Brackman's house, traveling most likely along Rock Creek Parkway at around 12:55 p.m. Then from 1:05 p.m. to 1:17 p.m., Becker was at Brackman's house.
Based on all of the evidence you collected at the conclusion of your investigation, as well as based on all of your experience, knowledge, training, skill, and education, did you form a conclusion as to what happened in Mr. Brackman's home on March 6, 2020?
Yes, ma'am. Based on all the evidence that we collected, the defendant went to the victim's house on March 6, 2020. She broke into the home and was discovered by the homeowner, Mr. Brackman. Mr. Brackman had attempted to use force against the defendant, but he was killed in the struggle.
Does the evidence indicate that the defendant went to the home intending to kill Mr. Brackman?
No, it does not. It was the middle of the day on a weekday, so it's logical for the defendant, to assume that Mr. Brackman was not at home, but at work. It may be that the defendant saw Mr. Brackman with a knife, got scared, and was just
Objection, Your Honor, speculation and lack of personal knowledge.
Response.
Your Honor, this witness is giving her conclusion as to what she believed happened in the house that day. She has more than enough experience and knowledge in this field to be able to form these kinds of conclusions from the evidence she collected. And
If I may respond, Your Honor.
You may, Mr. Chanel.
This witness repeatedly claimed it may have happened, or I believe, and I believe that this witness is not entitled to that kind of word choice or belief.
Well, this witness was endorsed as an expert. So the witness that is testifying as an expert can opine. So the objection is overruled.
Let me ask that question again. Does the evidence indicate the defendant intended to kill Mr. Brackman?
No, the evidence does not indicate that. It was the middle of the day on a weekday, so it's very logical for the defendant to assume that Mr. Brackman was not at his house, but instead at work. It may be that the defendant saw Mr. Brackman with a knife, got scared, and was just trying to defend herself. However, a death did occur, and that is still considered a first-degree murder.
Objection, Your Honor. Lack of personal knowledge. This witness does not have knowledge of the legal proceedings and cannot testify to what they just said.
Response, Your Honor?
Yes.
This witness is an expert, and she is also a homicide detective, so she knows that a death during a second-degree burglary is a first-degree murder.
The objection.
If I may respond, Your Honor.
I'm sustaining your objection, Mr. Chanel. The witness cannot draw a legal conclusion. That's for the jury to draw. Please continue.
Your Honor.
Go ahead, Ms. Skeeter.
I have no further questions, Your Honor. Thank you, Detective Markowitz.
Okay. Cross-examination.
Your Honor, may I get a brief time check on the cross-examination?
Of course.
All right, thank you. Good afternoon, Detective. Let's discuss your investigation of this case. You initially had the impression that the victim's mock trial activity had nothing to do with his death. Is that correct?
That was my first thought, but upon further investigation, you could tell that all the evidence pointed to it did in fact relate.
However, you mentioned that the culprit could have been a disgruntled ex-client. Is that right?
I thought that it could have, but it would have been very unlikely.
However, you began investigating Blair Rowlands, the son of a disgruntled ex-client who was sentenced to life in prison. Is that right?
I did do some investigation as I marked them on my CDR spreadsheet, but with all the evidence pointing to Miss Becker, it didn't really seem necessary to do a detailed investigation.
However, did you learn that Blair was absent the day of the murder with no alibi?
Yes, I believe that is what Van Owen said.
And during your investigation, you could not locate Blair because he fled the state?
I believe he did flee the state.
Thus, you stopped your investigation there because of this inconvenience?
Well, all the evidence pointed to Miss Becker, so it didn't seem necessary to continue investigating Rowlands.
So despite Blair Rowlands being absent on the day of the murder and now being absent from the state altogether, you stopped your investigation because they were gone?
So actually, Van Owen came up with those two conclusions after my investigation was mostly conducted.
Did you reach those conclusions yourself, though?
I did not actually. I had investigated them somewhat, seeing as I marked them on my CDR spreadsheet, but all the evidence clearly pointed to Miss Becker.
I now want to talk to you about the text messages you viewed. During your interview, Alex Cifuentes mentioned a text conversation that they allegedly had with Avery Becker. Is that right?
Yes, Alex Cifuentes did send me these screenshots of the conversation between him and Miss Becker.
And is it correct that you accepted photos of these texts from Alex with no validation or certification?
The screenshots were in fact sufficient because he forgot to bring his phone with him to the interview.
You mentioned a training course earlier, your 3-day course, where you learned to use forensic software like the Celebrite system to download information from a cell phone. Is that right?
Yes, that would be correct.
But you neglected to do so in this case and simply accepted photos of a text conversation in a murder investigation?
Well, in order to download the contents of Mr. Cifuentes' phone, I would have needed to have the phone. But seeing as he forgot to bring it with him to the interview, I just didn't have that accessibility.
And was it too inconvenient for him to ask him to bring his phone?
I really only needed the screenshots off of the phone. And so once he emailed them to me, I didn't see a purpose to have him bring his phone in again.
So let me get this straight. You never verified or validated these texts?
No, there would be no way to do that.
Except for the Celebrite system, of course.
Well,
I can't hear the witness. Can we have a time pause?
For a second. Yes, of course. Time pause, please. Let's give me.
My apologies, everyone.
Okay, she's back. Miss Maley, you're back, right?
Yes.
Okay, let's restart the time. Mr. Chanel, please repeat the question.
There are several ways to forge a text conversation, is that right?
Objection, Your Honor. Outside the scope of this witness's expertise.
The objection is overruled. You endorsed her as an expert, so she can answer. Go ahead, Mr. Chanel.
There are several ways to forge this text conversation, is that right?
There could be ways such as Photoshop, but it'd be very difficult, and I wouldn't expect a teenager such as Mr. Cifuentes to know how to do that.
So you assumed they were real and moved on with your investigation?
Objection, Your Honor. Asked and answered. This attorney has already asked multiple times if she has verified this evidence.
Response, Mr. Chanel?
I was just making sure that it was heard because of the technical difficulty.
Okay.
But I can move on if you'd like.
I think we all heard the answer. The objection is sustained. You may continue.
All right, Detective Markowitz, let's talk about the call detail records you obtained. Is it true that these CDRs cannot provide the specific location of a person's phone?
No, but they do give you a very accurate response, seeing as you can see the specific cell towers and even specific antennas on those cell towers.
And is it true that these phones can connect from 6 or even 7 miles away?
Yes, that is true.
And there's actually no way to determine who's in possession of the phone when these CDRs are taken, right?
Well, I would not be able to determine that, seeing as I was not there, no.
And Mrs. Becker's phone was lost on the day before the murder?
That is what she claims, but all the evidence points to her having it.
So the location of the phone could have shown her or any other person with her phone driving on a nearby road, is that right?
The CDR records indicated where Miss Becker's phone was. Now, as to who had that phone, that would be part of my job in conducting this investigation. And like I said, all the evidence did point to Miss Becker.
Is it true that the phone could have connected to all 3 of these towers, even if it was still sitting at the Fry Shack or the mall?
It would be rare, but I mean, it is possible.
You also pointed out that the few calls and texts made on the way, on the afternoon of March 6th were all very short. Is that right?
Yes, that is correct, because they were unanswered text or calls.
And is it true that these calls may have been made in an attempt to locate Mrs. Becker's phone?
It could be that, but all the evidence indicates
Thank you, Your Honor. No further questions at this time.
Okay. Redirect, Ms. Keeter.
Yes, Your Honor. Detective Markowitz, did any of the evidence in this case point to Blair Rollins?
No, all of the evidence that I have investigated, as well as my colleagues, clearly point to Miss Becker committing this crime.
Thank you, Detective Markowitz. No more questions, Your Honor.
Okay. Does the prosecution rest?
The prosecution rests, Your Honor.
Okay. Are we moving on to the defense's case?
I believe so, Your Honor. May we call our first witness?
Yes, you may.
The defense calls Avery Becker to the stand.
Good afternoon, Ms. Becker. Let me swear you in. If you could please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead, Ms. Elsie.
First, please state your name and spell your last name for the record.
My name is Avery Becker, Becker being spelled Becker.
How do you know the deceased, Mackenzie Brackman?
Mr. Brackman was the coach of my old mock trial team.
And what was your relationship with Mr. Brackman like?
You know, it was not always the best. We kind of had a rocky relationship, and I'll be the first to admit it. I had a natural affinity for mock trial, and he liked things a little bit more orderly, and our personalities always just kind of clashed.
And how did Mr. Brackman demonstrate his negative feelings towards you?
You know, it was just kind of a lot of stuff here and there. Like, it almost felt as though nothing I could do was right. He was very nitpicky towards me. There was a couple big incidences, though, such as when I was demoted to the B team, and then one time he blew up on me for going off script, and of course, when I was eventually kicked off the team.
Was this upsetting for you?
Well, of course, I think that anyone would find it upsetting. I never got validation for anything I did right, even when I did do well. It was very upsetting.
Did you ever act on your negative feelings towards Mr. Brackman?
Yeah, regrettably. At one point at a practice, shortly after a regional tournament, I had won the Best Attorney Award and Best Closing Statement, and then Brackman came in and just started yelling at me.
Objection, Your Honor, hearsay.
Response.
This is going to the effect of what Mrs. Becker observed. She observed that somebody yelled at her.
The objection is overruled. You can answer.
Yeah, so Brackman was just yelling at me, and he was saying some incredibly hurtful things, so I did storm out. And previously I had been at the whiteboard writing with an expo marker, so I had that, what I thought was an expo marker in my hand. I went out to his car, and then I wrote on his Porsche again in what I thought was an expo marker.
And how did you feel about vandalizing his car after the fact?
I instantly regretted it. I tried repeatedly to apologize to Brackman about it. I felt so awful afterwards. I even went in to talk to his secretary to try to apologize in person, and he just wouldn't see me. I really regret it.
And how did he react to all of your apologies?
He just ignored me, and that was the most hurtful part. Like, you would think that a coach would try to reach out to his student, maybe be the bigger person, but he just ignored me.
And was it your goal to help or hurt the team?
My goal was never, ever to hurt the team. I really, really did love mock trial, and I enjoyed every second of it, so of course I wanted to help the team.
And what other relationships did you have with members of the mock trial team?
Well, I had a relationship with each member on the team, but my best friend Taylor Perkins did join the team with me.
And what was your relationship with Taylor Perkins like?
We were super close. Like I said, we joined the team together because we thought it would be fun to be with each other all the time, and it was.
And where were you at the time of Mr. Brackman's death?
I was with Taylor all day, actually. I had lost my phone the night before, and then Taylor was with me all day trying to look for it.
And are you familiar with Alex Cifuentes?
Yes, Alex is another member on our mock trial team.
What is the nature of your relationship with Alex Cifuentes?
I mean, we've never gotten along.
Objection, Your Honor, speculation. This witness is trying to testify about things that Alex Cifuentes may have thought, not statements or anything like that, anything she could have personally observed, but merely her own speculations about this.
May I respond, Your Honor?
Yes.
The witness is simply testifying to the relationship she had with Alex Cifuentes. She was a part of that relationship. She should be able to testify whether it was a good-natured relationship, a bad-natured relationship.
The objection is overruled. The witness can testify about her opinion or her impression of the relationship.
So, yeah, Alex and I never really got along. I don't know. We kind of butted heads with things. Like I said, I kind of had a natural affinity for mock trial. Things always came easy to me. I noticed that Alex was a particularly hard worker, which I do respect, but it felt from my point of view that Alex could sometimes get jealous of the fact that I didn't have to prepare as much as he did.
Alex Cifuentes insists you sent him messages that you planned to trash Mr. Brackman's house. Is this true?
Absolutely not. First of all, I don't know why I would send those kind of messages, and the fact that I'm being accused of that is ridiculous. And second of all, Alex would be literally the last person I would text something like that to.
Was he at the Fry Shack where you lost your phone?
Yes, he was there along with some other mock trial members that night.
And do you know Blair Rollins?
I do. I don't know him well, but I know that he went to school with us.
Did Blair Rollins like Mr. Brackman?
Objection, Your Honor. Speculation and beyond the scope.
Response, please.
Yes, this witness is just testifying to what she observed about other possible suspects and her relationship with them.
The objection is sustained. The witness needs to lay a little more foundation about how she would know the answer to that question.
How do you know Blair Rollins?
So I went to school with Blair Rollins, and I have kind of learned or come to know that Blair had a history with Brackman through a trial case that
Objection, Your Honor.
What is
Objection, Your Honor. Speculation and lack of foundation. Also hearsay.
Response.
She's simply stating what she knows about the witness, and that is laying the foundation for her further testimony.
Response, Your Honor.
Yes, go ahead.
Anything that Ms. Becker is about to elicit about Blair Rollins or any relationship thereof must be hearsay because it is an out-of-court statement. There is no other way this witness could know that. And even if she does know that, it is speculation because she does not have personal knowledge about this. So there's speculation, there's a lack of foundation, as well as these statements would be hearsay.
The objection is sustained as to hearsay. Ms. Becker can testify, but not about out-of-court statements made by the other person.
Thank you. Did you want to harm Mr. Brackman?
No, that was absolutely never my intention. We did have a rough relationship at times, but there are so many people and high schoolers that have terrible relationships with their coaches, but that never means that they actually want to kill them. I never had any intent to actually harm Mr. Brackman. That is absolutely ridiculous.
Did you harm Mr. Brackman?
No, and I'm honestly kind of offended that anyone thinks that I would. I did respect him ultimately. He did help us get to a higher place with our mock trial team, and I am so sad that he's not here with us anymore.
No further questions at this time.
Cross-examination, Ms. Wind.
Yes, Your Honor. Ms. Becker, I have just a couple questions for you as well. First, about your relationship with the victim, Mr. Brackman, in your own words, you hated him, right?
Like I said, I did not really like him. We had a bad relationship, and he was never kind to me, so the feelings were kind of mutual in that sense.
But those were your words that you hated him, right?
Yes, like I said, hatred doesn't equate to killing someone, though.
And again, in your own words, Mr. Brackman hated you as well, right?
Yes, but that still doesn't mean I want to kill him.
Now, let's discuss some of the reasons for this mutual hatred. You have previously said that Mr. Brackman was always critical of you, right?
Yeah, it kind of felt as though I could never really do anything right.
You've also said that his role is simply to attack you, right?
It did sometimes feel like that, yes.
And Mr. Brackman would go nuts when you didn't do what he wanted, right?
Yeah, like I said, he didn't really acknowledge the fact that I had a natural affinity for mock trial and didn't necessarily have to prepare as much as some people do, and that kind of bothered him, so he did attack me in that sense.
And because of that, you argued at almost every practice, right?
Yes, our personalities definitely clash, so we did argue pretty frequently.
Mr. Brackman always unfairly accused you, right?
Objection, this calls for hearsay. According to Rule 804B, a deceased person cannot be used, their statements cannot be used.
What is the response, Ms. Wind?
Your Honor, I'm not asking about any specific statement, just if Mr. Brackman had a history of criticizing Ms. Becker. That's not asking for any specific words of Mr. Brackman's, just that he did that those were his actions.
The objection is overruled.
So he did always unfairly accuse you, right, Ms. Becker?
Accuse me specifically of what?
Of being lazy, right?
Oh, yes, he definitely did accuse me of that, and that was honestly kind of hurtful.
And you said to your adult coach that he wouldn't know a good cross-examination if it hit him over the head, right?
I mean, I did say that. Like I said, he said some really hurtful things towards me, so in the heat of the moment, some things did come out.
Yeah, I mean, Mr. Brackman didn't just criticize you privately, he did it in front of the whole team, right?
Exactly, and I think that anyone would make some statements they regret if they were publicly humiliated in front of all of their peers.
Ms. Becker, in addition to these bad feelings about one another, several times your relationship went farther than words, right?
Are you referring to the car? Because I had already talked about how that was a regret for me.
Let me just go over a couple of those instances real quick. First, before the regional tournament in 2020, Mr. Brackman demoted you from the A team down to the B team, right?
Yes, that is correct.
And number two, when you won an award at regionals, Mr. Brackman criticized you and you called him the worst coach in the state, right?
Well, before that, he had told me about how I was going to cause our entire team to fail at state.
Miss Becker.
So yes, I did.
Miss Becker. Miss Becker, that was not my question. If you would please listen to my question and answer that instead of being cumulative for the jury. You called Mr. Brackman the worst coach in the state, right?
I called him that, yes, after he said some hurtful things to me.
And then you took some sort of marker and wrote worst attorney awards in giant letters on his car, right?
I wrote that with the expo marker I thought I had in my hand.
And you know, Miss Becker, that kind of act is a crime, right?
Yes, and like I said, I regret it deeply, but in the heat of the moment, that's just kind of how I felt.
And on the spot, when Mr. Brackman had seen what you had done, he exploded and kicked you off the team, right?
Yes, and I admit that was honestly a proper reaction. My actions were not ideal, and I regret it.
And on that occasion, using your own words, Mr. Brackman yelled at you, "What the hell have you done to my car?"
Objection, this is hearsay.
Response,
Your Honor?
Yes.
These statements are simply being offered for the effect on the listener. I believe opposing counsel had also offered similar statements earlier for effect on the listener, simply as things that caused Mrs. Becker to then go and do something. So therefore, we are not asking them for the truth of the matter, but rather for the effect.
Okay, thank you. The objection is overruled. Please continue, Ms. Becker.
Can you please restate the question?
Yes. So on that occasion, after you drove his car and he saw what you had done, Mr. Becker yelled at you, Mr. Brackman, excuse me, yelled at you, "What the hell have you done to my car? That's it. I have had enough of your crap. You don't work, you screw around in practice and are disruptive. You talk behind my back, and now this. I have had it. You are off the team." Those were his words, right?
Yes, those were his words.
And again, in your own words, that made you, quote, even madder than getting criticized in front of the whole team, right?
I mean, those were some pretty hurtful statements that you just said, so I was very upset.
Finally, Ms. Becker, immediately after you got kicked off the team, you went home and told your own mother that Mr. Brackman got mad at you for no good reason, right?
I was ashamed of my actions, and I didn't want to admit that to my own mother, what I had just done, as I think most people would agree with, so I did leave some things out.
So you didn't tell your own mother the truth. You lied to your mother, right?
Yes, because I was ashamed of what I had done.
But you did confess to her, and I quote, that you would get back at Mr. Brackman if it was the last thing you did. Were those your words?
Yes, but I had no ill intention with that. I just wanted to prove to him that I was a good mock
Ms.
trial
Becker,
student.
that was not my question. My question was simply if these were your words, that you would get back at Mr. Brackman if it was the last thing you did. Yes or no, please?
Yes, those were my words.
Thank you. No further questions, Your Honor.
Okay. Redirect, Ms. Elsie.
Yes, Your Honor. When you said that you wanted to get back at Mr. Brackman, what did you mean?
I had absolutely no ill intentions with those words. I just wanted to prove to him that I was a good mock trial student and that I could be on the team. I wanted to show him that what I did was not an act of hatred, and I wanted to prove to him that I belonged on that team.
Did you kill him?
No, no, of course not. People have bad relationships with each other and they blow up on each other, but that does not mean that I wanted to kill him.
Do you think there is a difference between perhaps being vengeful and wanting a disagreement and wanting to murder someone?
Objection, Your Honor, beyond the scope of cross.
May I respond?
Yes.
The whole cross tried to identify how the negative relationship might cause Miss Becker to react. So I just wanted to specify how she might react to those negative comments.
The objection is overruled. Ms. Becker can answer the question.
I'm sorry, could you please restate the question?
Yes, do you believe there's a difference between feeling vengeful and maybe having a slight disagreement with somebody and not wanting to love them, being their best friend, or wanting to kill someone?
Absolutely. Just because me and Mr. Brackman might not have liked each other doesn't mean that I wanted to act violently on those feelings. We just didn't have a great relationship.
No further questions.
Okay. Next witness, please.
Your Honor, the defense now calls Mr. Taylor Perkins to the stand.
Mr. Perkins, could you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Go ahead, Mr. Decker.
Thank you. Mr. Perkins, could you please state your full name and spell your last name for the record?
Yeah, Taylor Perkins, Perkins being spelled Perkins.
Thank you. And what is your relationship with Mrs. Avery Becker?
You know, me and Avery were pretty good friends. We've known each other for a good amount of time. And Avery's one of the main reasons I'm even on mock trial to begin with.
Could you please describe your experiences with Avery during mock trial?
Yeah, Avery was always the type of person to, even if she came unprepared, she'd be able to do anything, come up with things on the fly. It seemed pretty cool to me, but it seemed that it didn't really float the boat with Coach Brackman, though.
So, based on your experience and observations as a member of the mock trial team, what did you observe about the relationship between Coach Brackman and Mrs. Avery Becker?
Brackman and Avery would always have some feuds. I thought they were pretty funny. Sometimes you could even see steam coming out of Coach Braxton's ears, which made it even more funny.
And what would Avery do about this little feud that they had?
Avery would typically, Avery would typically get upset from these comments. It's always pretty degrading to Avery.
And what would Avery do about these little comments?
She would go and then sometimes pull little pranks on Brackman, usually to no effect, but sometimes there can be accidents.
Thank you. After the competition, did these disagreements ever boil over?
Yeah, after a competition, Avery came unprepared, but being a natural at mock trial, Avery could just, as I said, come up with things on the fly, and it went off without a hitch. But after this competition, Brackman demoted Avery to the B team, which was not fair. It's Avery's senior year, as long as mine, but I never really cared for mock trials. I don't really care, but it was Avery's senior year. She'd done it for all 4 years. It wasn't fair.
When Avery was demoted to the B team, what made you step down?
I never cared for mock trial. I don't even want to become a lawyer in the first place. So I decided to be a good friend and let Avery take my spot so that she could enjoy mock trial, something she loves, for the remaining time she had.
Thank you. Mr. Perkins, did you ever observe any more heated exchanges between Avery Becker and Coach Mackenzie Brackman?
I heard there was a feud between Brackman and
Objection, hearsay.
Response, Mr. Decker.
Your Honor, my witness is merely testifying about something that happened, not exactly any words in particular.
Your Honor, I believe it was Mr. Perkins' own words that he heard about a feud between the defendant, Mr. Brackman. Therefore, the only way that he can testify about this is through hearsay.
I heard him say that as well. The objection is sustained.
Okay. Mr. Perkins, what happened with Coach Brackman's car?
It was vandalized by Avery, but it was just an honest prank that was trying to be harmless. It just went wrong, though.
The objection, could you repeat that, Mr. Holtzinger?
I objected to speculation.
Response.
Your Honor, what grounds is opposing counsel objecting to speculation?
I'm objecting to speculation on the grounds that Mr. Perkins is being asked to testify about the defendant's motives for vandalizing Mr. Brackman's car, something that they wouldn't know outside of speculation.
Mr. Decker, I'll allow Mr. Perkins to answer if you lay a little more foundation, okay?
Okay. Mr. Perkins, would you consider yourself friends with Avery Becker?
Yeah, we've known each other for years. Pretty good friends at that, maybe best.
And did the two of you talk a lot?
Yeah, we would typically speak to each other quite frequently. We were pretty good friends. Avery picks me up from school a lot, so.
Did Avery ever reveal to you the reason behind why she vandalized Coach's car?
Objection.
Yeah.
I'll say that again, Mr. Holtzinger.
I objected to hearsay.
Response.
Your Honor, this doesn't really, this is a state, I'll move on.
Okay. You did not ask for a statement, Mr. Decker.
Okay.
Go ahead. You can ask the question.
Thank you. Mr. Perkins, so could you remind me once more, what happened with the car?
Yeah, it was
Objection asked and answered.
The objection is overruled. I think we lost the track a little bit here, so I'll allow the question so we can regain track. Go ahead, Mr. Decker.
Thank you. Mr. Perkins, would you like me to ask the question once more?
I think I can get it from where I was leaving off, but Avery just wanted to pull a little prank on Brackman, just wanted to make it a little harmless expo marker prank, but it ended up being a permanent marker. It was her mistake, but it was honest that it was just a mistake.
Thank you. Did anything happen after Avery vandalized Coach Brackman's Porsche?
Yeah, Avery was kicked off the team. I thought it was pretty unfair. She tried everything she could to try to get back on the team. She even offered to pay for the damages caused, which didn't really seem extremely fair to me.
Did Avery end up getting back on the team?
No, after this, Avery was kicked off the team. We tried to talk to Coach Brackman about her getting back on the team.
Mr. Holsinger, what out-of-court statement are you objecting to?
Mr. Perkins was testifying that he and the defendant attempted to talk to Mr. Brackman about something. This is an out-of-court statement being offered for the truth of the matter.
Your Honor, may I respond?
Yes.
Thank you. There was no statements. My client or my witness merely stated that they spoke with Coach Brackman. This is an action. There's no statement being made. There's no claim being made.
The objection is overruled. Also, Mr. Perkins is testifying and subject to cross-examination as we speak. Go ahead.
Thank you. What did you and Avery do after the failed attempt to get Avery back on the team?
We tried to talk to everyone on the team. It was to no avail, though. They tried to help her, but I don't know. But we went to the Fry Shack after that just to kind of hang out, let Avery cool down a little bit. That was just a big mistake overall.
What happened at the Fry Shack?
We ran to the mock trial team at the Fry Shack, which they expressed some condolences to Avery, but Alex Cifuentes was just being very passive aggressive towards Avery the entire time.
So, do you know if Avery had her phone when she left the Fry Shack?
Objection speculation. There's been no foundation laid to whether or not they would know.
Your Honor, may I respond?
You may, Mr. Decker.
My witness was with Avery at the Fry Shack. He just testified to that. He was there to see whether or not Avery may or may not have left her phone at the Fry Shack.
The objection is overruled. The witness can answer if he knows.
Mr. Perkins, do you know whether or not Avery had her phone when leaving the Fry Shack?
We're pretty sure Avery didn't. Like, next day, we spent the entire day looking
Objection
for it.
speculation. You just said we're pretty sure we know. This is still speculative.
The objection is overruled. The witness can testify how certain he is, whether he knew, and that goes to weight, not admissibility, so I'll allow it. You can continue, Mr. Decker.
And so were you with Avery throughout the entirety of the next day?
Yeah, from the morning to the time we found the mock trial team at the Fry Shack. I was with Avery the entire time. We were looking for the lost phone. We decided to retrace some steps, go to the mall, which we went to after the Fry Shack, and then back to the Fry Shack just to see if any of the previous employees there had found the phone.
Thank you. Did you have any luck finding the phone?
Nope, no luck was had there.
And where did the two of you search for Avery's missing phone?
We retraced the steps, went to the mall, went to the Fry Shack, just places we had been the previous day, just to see if we could find it.
And what did the two of you do after searching for the phone?
We went back to the Fry Shack. That was just to see if it was there, but we ran into the mock trial team. They were there for some reason, which we thought was strange. They should have been at mock trial, but I guess the 15-minute rule applied there. They left, and we're wondering where.
Non-responsive.
Response, Mr. Decker?
Yes, I believe that my witness answered my question fine. He testified that after they were searching for the phone at the mall, they went to the Fry Shack to get some food.
Your Honor, Mr. Perkins' statements, he went on to say, to talk about the mock trial team, that they were there and why they were there, and that doesn't fall under the scope of the question that Mr. Decker asked him.
The objection is overruled. You may continue, Mr. Decker.
Thank you. Mr. Perkins, what did you learn when you went to the Fry Shack?
Coach Brackman was not in attendance at mock trial, which was unusual. And it was scary to think about, but while we were talking there, Brackman was dead.
So did you learn about Coach Brackman's death at the Fry Shack?
No, we found out later on.
So I'm going to switch the focus here. Do you know who Blair Rollins is?
Yeah, they're another student at a CHS. Kind of a weird dude, if you ask me.
And based on what you've seen of Blair at school, what was he like?
Pretty weird. Everyone thought that as well at the school.
Objection, hearsay.
Response.
Your Honor, my witness is not using any statements, merely responding to what he knew about Blair based on his experience with him at school.
I'll allow it. The objection is overruled.
Thank you. Mr. Perkins, would you like me to re-ask that question?
Sure.
Okay. Based on what you've seen of him at school, what is Blair like?
He was a pretty weird dude. Everyone thought that as well. You could ask 50 people and they would agree with me.
And were Blair Rollins and Alex Cifuentes friends based on your knowledge of them at school?
From what I could tell, yeah. And as the saying goes, opposites attract. So who knows?
And so in and around the time where Avery claims to have lost her phone, did Alex Cifuentes have access to this phone?
Objection,
Yeah.
speculation.
Your Honor, may I respond?
Yes, Mr. Decker.
Thank you. It is known that both my witness, Taylor Perkins, and also Alex Cifuentes were at the Fry Shack, and they engaged in conversation.
Your Honor, no foundation has been laid that Blair Rollins was at the Fry Shack at that time, so this is still speculation and lack of foundation.
Yeah,
Your
the
Honor, may I
objection
reply?
is sustained. You'll have to lay a little more foundation, Mr. Decker.
Okay. Mr. Perkins, I think we might have touched on this earlier, but who was at the Fry Shack the first time you were there?
Alex Cifuentes, along with the entire mock trial team.
Thank you. And while you were there, at any point, did Alex have access to Avery's phone?
Yeah, Alex was sitting with us, making some passive-aggressive comments towards Avery. But yeah, they were there with us at that time.
Thank you. So, by your knowledge, is it possible that Blair could have been in possession of Avery's phone?
Objection, speculation.
Sustained.
And considering that you were with Avery the whole day, is it possible that Avery could have killed Coach Brackman?
No. There's no possible way Avery could have left being with me and killed Brackman. We were with each other the entire day, so there was no time or anywhere we could have gone. You could trace my phone if you want to see where we were as well.
Thank you, Mr. Perkins. Your Honor, we have no further questions at this time.
Okay. Cross-examination, Mr. Holzinger.
Yes, Your Honor. Mr. Perkins, I have some questions for you as well. I'd like to discuss your relationship with the defendant as you testified on direct. First, you state that you are best friends with the defendant.
Yeah, we're pretty good friends, if not best friends. That is true.
That means you spoke with the defendant frequently, doesn't it?
Yeah, since we're friends, we would.
And in fact, even after Mr. Brackman was murdered and you found out you were going to be a witness at trial, you and the defendant were able to get together and talk about the day of the murder?
Yeah, we were gonna meet up with each other anyways. I mean, we're friends, so.
And as a matter of fact, you made sure your stories matched, didn't you?
We were with each other the entire day. I was there to confirm her alibi.
Mr. Perkins, I didn't ask if you were with the defendant the entire day. I asked that you made sure that your story matched with the defendant, didn't it?
We talked about the murder. We never really were planning on matching our alibis or whatever.
Mr. Perkins, you wrote a witness statement for this trial, correct?
I did, but we may have discussed the
Could you
contents.
please turn to that witness statement?
Sorry, I do not have it in front of me right now. Thank you.
All right. Please turn to the last page of your witness statement. Is that your signature at the bottom of the page?
Yes, it is.
Lines 112 state, I have carefully reviewed the statement. It is true and accurate and includes everything I know of that could be relevant to the events I discussed. Did I read that correctly?
Yes, you did.
Please turn to line 107 of your witness statement.
Yeah.
Does it say, I know Avery and I were not at school either, but we were together. Our stories match. Did I read that correctly?
Yeah, but it seems you were trying to say we.
Let's talk about Mr. Brackman. The defendant didn't like Mr. Brackman.
One moment, Mr. Holzinger, let Mr. Perkins finish, okay?
All right.
Yeah, I believe your question was going on if we concluded to make sure our witness statement matches. That just goes to show that we were with each other and that our stories that we both provided did indeed match. That doesn't mean we came together, collided with each other, and said, oh, let's go and make our stories match.
But
That
Mr.
just says-
Perkins, I read correctly on your witness statement that you said that you made sure that your stories matched, correct?
It says we were with each other the entire day. Then it goes on to say, comma, our stories match. That never says anything along the lines of we came together and made sure our stories match.
Let's talk about Mr. Brackman. The defendant didn't also like Mr. Brackman, did she?
Brackman has always given her a hard time. I mean, it makes sense why she wouldn't really like him.
You also did not like Mr. Brackman, did you?
Not really. I mean, as the saying goes, if you're bad at something, become a coach.
Let me clarify, just like the defendant, you considered him a mediocre coach, didn't you?
Yeah. I mean, I never really saw him as a great coach.
Just like the defendant, you considered him a bad
Objection,
lawyer.
Your Honor. This calls for speculation. He's stating, just like the defendant, indicating that Mr. Perkins would know what the defendant is thinking at the time, which Mr. Perkins would have no knowledge of.
Your Honor, I already laid the foundation that the defendant didn't like Mr. Brackman and that they spoke constantly about Mr. Brackman. So I'm saying that just like the defendant, they considered him a bad lawyer in real life. And I'm asking if that matches the defendant as well.
The objection is overruled. Mr. Decker also brought up the fact that Mr. Perkins and the defendant are close friends and know each other well. Go ahead, Mr. Holzinger.
Mr. Perkins, just like the defendant, you considered Mr. Brackman a bad lawyer in real life, didn't you?
Yeah, I didn't really see him as a great lawyer in general.
Mr. Brackman once demoted the defendant to the B team, correct?
Yeah, which I thought that was pretty unfair. And to be a good friend, I gave up my spot, which, as I said, I don't really care about mock trials. So that was a pretty easy decision for me.
Mr. Perkins, I didn't ask whether or not you thought it was unfair. I just asked that the defendant was demoted, wasn't she?
Yeah, she was.
And you quit the team so the defendant would be back on the A team, correct?
Yeah, I had no reason to be on the team in the first place. I mean, I don't even want to be a lawyer. And if it made my friend happy, then I'd be more than glad to give up my spot.
Because of her feelings toward Mr. Brackman, the defendant destroyed the paint on his car, correct?
In an accident and just trying to pull a harmful prank. Yeah, that did happen.
On the spot, Mr. Brackman kicked the defendant off the team, correct?
Yeah, I thought it was pretty unfair. I mean, she tried to do everything she could to even pay for the damages.
Mr. Perkins, I didn't ask whether or not you thought it was fair, just that Mr. Brackman kicked the defendant off the team, correct?
Yeah, that did happen.
And because this was the defendant's senior year, that means she lost her last opportunity to be on the team, correct?
Yeah, at that point. So she was pretty desperate to keep with something she loved and get back on the team.
Finally, let's discuss your story about the day of the murder. You've stated that Ms. Beckers is so committed to her cell phone that it is like her third kidney, correct?
Yeah, and then that's when I realized that she didn't have her phone on her the day of we were going to search for it.
Mr. Perkins, I just asked whether or not you said that Ms. Becker's phone was like her third kidney, correct?
It could be considered that, yes.
Objection, Your Honor. This is hearsay.
Your Honor, I don't know what grounds this is being offered as hearsay. I'm just asking whether or not Mr. Perkins thought the defendant's phone was like her third kidney or not.
The objection is overruled.
Mr. Perkins, you know that her phone was never out of her reach, correct?
Yeah, which is why we thought it was weird that she was missing it.
Yet it is your testimony that the defendant left the fry shack without her cell phone?
Oh, we believe that could have happened. I mean, she could have been emotionally distressed from seeing the mock trial team or even talking to Alex Fuentes. So
but she did leave the fry shack without her phone, correct?
We believe so, yes.
And she also spent the whole night at her home without her cell phone?
I don't know what happened at her house. She could have gone straight to bed or whatever. But yeah, she went that night without her phone.
She also woke up and got ready for school without even trying to look for her phone?
I guess so, yeah.
She also picked you up at your house to go to school the day of the murder, correct?
Yeah, that's a pretty routine schedule between two of us, so we don't really need phones to do that.
And only after all this, only then, did you two realize she didn't have her phone, is that correct?
Yeah, I realized she didn't have her phone when she picked me up.
Finally, Mr. Perkins, you agree that the defendant had an inflated ego and can be rash, correct?
While she does have an inflated ego and may be rash, that does not mean she's irrational enough to commit a murder. That's just
Mr.
insane.
Perkins, I didn't ask whether or not you thought that she was rational enough to commit a murder. I just asked that you think that she had an inflated ego and can be rash. Is that correct?
Objection, Your Honor. This is improper character evidence.
Response?
Your Honor, this is not improper character evidence because character may be proven by reputation or opinion. This is her reputation among Mr. Perkins and the rest of the mock trial team. It is Mr. Perkins' own observation that the defendant had an inflated ego and could be rash, and that is proven through her reputation among the mock trial team.
Your Honor, may I respond?
Yes, Mr. Decker.
Pursuant to Rule 404, as this is improper character evidence, it is not admissible because it's trying to use the fact that Avery could be rash and unpredictable in order to prove that she murdered Coach Brackman. This is
Your Honor,
proper character.
Let him finish.
Yep.
Okay.
Your Honor, I am merely proving by reputation or opinion of Ms. Becker under Rule 405 that this is her reputation or opinion. So therefore, under Rule 405, this is admissible and it's not improper character evidence.
The objection is overruled. Mr. Decker is referring to prior bad conduct. That's different under 404. Go ahead, Mr. Holtzinger.
Let me repeat the question. You agree that the defendant had an inflated ego and can be rash, correct?
While she may have an inflated ego and may be rash, she's not irrational enough to commit a murder.
Mr. Perkins, I'm asking a simple yes or no question. You believe that she had an inflated ego and can be rash, correct?
Yes, but not irrational enough to commit a murder.
And in one of those rash moments with trashing Mr. Brackman's car, using your own words, the defendant needed to let off steam and freak Mr. Brackman out. Is that correct?
Yeah, but it's just meant to be a harmless prank. She thought it was a permanent or an expo marker, sorry. But I don't see how being a harmless prank.
Those were your words, correct?
Yes.
Thank you. No more questions, Your Honor.
Redirect, Mr. Decker.
Yes, could I get a brief time check? Okay, I'm gonna assume 10 minutes. I think that's what I see. So, Mr. Perkins, were you with Avery the entire day?
Objection asked and answered.
I'll overrule it. I think Mr. Decker is trying to get to something. He's just laying some foundational facts. Go ahead, Mr. Decker.
Thank you. Mr. Perkins, were you with Avery the entire day?
Yes, we were with each other the entire day.
Thank you. Did you and Avery collaborate and make your stories match?
No, I was just saying how our stories match and that you can see that we were with each other the entire day.
Thank you. Does being a bad lawyer mean that someone does not deserve to live?
Definitely not.
And would killing Coach Brackman get Avery back on the A-team?
Objection speculation.
Mr. Decker.
Your Honor, the witness is a member of the mock trial team. I think he could pretty well say whether or not Avery would be back if the coach was dead.
The objection is sustained. It's somewhat argumentative and calls for speculation.
Okay, I'll move on. Mr. Perkins, to the best of your knowledge, was it normal for Avery to pick you up?
Yeah, we would do it quite frequently, so it would make sense, even if she didn't have her phone, that she would pick me up. I mean, we had it planned.
Thank you, Mr. Perkins. No further questions at this time, Your Honor.
Okay. Next witness.
Your Honor, the defense calls Mr. Blake Van Owen to the stand.
Mr. Van Owen, could you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Go ahead, Mr. Chanel.
Good afternoon. Could you please state your first name and spell your last name for the record?
My name is Blake Van Owen, Owen being spelled O-W-E-N.
And what is your job, Mr. Van Owen?
I work as a private investigator, professor, and expert witness in police practices, but do please call me Professor Van Owen.
Do you have any experience working with law enforcement?
I do, yes. I work in the Aurora Police Department.
And why did you leave the force?
I became a bit disillusioned with police work after I saw some of the flaws in its tactics and techniques.
And where do you work now?
I now work in private investigation.
What education do you have in this field?
Well, beyond my training at the Aurora Police Department, I also obtained a master's degree in criminal justice.
And can you explain your position as an educator?
For the last 5 years, I've taught a course at CU Denver on police practices and social justice.
And you said you also work as an expert witness. Can you explain that a bit further?
Yes, I regularly serve as an expert witness in a variety of fields, including police practices, false arrest, forensic evidence techniques, crime scene reconstruction, cell tower analysis, among many other fields, all of which are actually pertinent to today's case.
And how many cases have you been consulted for?
I've been consulted for well over 100 cases in my extensive career.
Your Honor, the defense moves to move Professor Blake Van Owen as an expert in the fields of general police investigation tactics, false arrest, cell tower analysis, and crime scene reconstruction pursuant to Rule 702.
Any objection, Ms. Skeeter?
Your Honor, we object to the cell tower analysis portion. We believe that this witness cannot have any foundation laid for that expertise.
The objection is overruled. Mr. Van Owen can testify as an expert in the areas Mr. Chanel just disclosed.
Now, Professor Van Owen, let's discuss your involvement in this case. How did you initially become involved?
I was hired by the counsel that represents Avery Becker in today's case.
And what is your opinion on the police investigation?
Well, based on my training, it's pretty clear that this police investigation was rushed. The police came to an easy conclusion.
What parts of the investigation did you view?
I reviewed the police reports, Kyle Kuzak's crime scene reconstruction, as well as the cell tower reports and exhibits prepared by Detective Markowitz for today's case. These two neglected a lot of important information.
What do you think was the root cause of this flawed police investigation?
One of the biggest problems that I found that led Detective Markowitz and Kyle Kuzak, or Mrs. Kuzak, I apologize, to their conclusions was a lot of just easy conclusions and assumptions. There was a lot of confirmation bias in this investigation.
Can you explain what this confirmation bias is?
Confirmation bias is an interpretation of new evidence as confirmation of one's pre-existing beliefs. It was heavily prevalent in Detective Markowitz's investigation as a whole.
Let's discuss the crime itself. Why does the detective believe the victim had armed himself?
You see, Detective Markowitz believes that Mackenzie Brackman likely had his phone near him, saw the notification from the Ring doorbell cam of someone at his front door, and then grabbed a knife because there was someone there. Detective Markowitz assumed that the victim prepared himself to defend against a mailman or a milkman.
And does this seem like the logical explanation to you?
Not at all. As someone with the Ring doorbell myself, I don't necessarily grab a knife every time my phone buzzes.
And what was your conclusion?
Well, if the victim and intruder had been facing each other face to face, the intruder would have had to be much taller than Mackenzie Brackman in order to stab Brackman over the shoulder at a downward angle through his aorta. The Ring videos make it clear that this was not the case. It leads me to conclude that Mackenzie Brackman would have been sitting with the intruder standing behind him.
And what does this mean in the context of this investigation?
It seems that the intruder had actually set out to kill Mr. Brackman, and Mr. Brackman had not necessarily interrupted a random burglary. This directly conflicts with Detective Markowitz's theory.
Let's talk some more about the cell tower records involved in this case. What can be confirmed from these records?
Well, at the very most, the records confirm that Avery Becker's phone connected to various towers throughout the afternoon.
And is that it?
Yeah, but that's far from saying Avery Becker was anywhere near Mackenzie Brackman's home.
Can you explain that a little further?
Well, as I'm sure you've heard today, there's evidence that Avery Becker lost her phone the day before the murder, March 5th, and Taylor Perkins confirms that the two were at the mall and Fry Shack during the time the break-in occurred.
Do you have any issues with conclusions reached by the prosecution regarding cell tower data?
I do. I found that there were some pretty far-fetched conclusions regarding the tracing of Avery Becker's phone. First off, phone records are not GPS. We don't know exactly where the phone was on March 6th, but we know that it was within 6 or 7 miles of the 3 towers it communicated with on that day.
And to help the jury better understand these distances, how far is the Fry Shack from these 3 towers?
Well, for reference, the 2 furthest towers from the Fry Shack are both approximately 2 miles from that location. A phone at the fry shack easily could have connected to any of the 3 towers on the diagrams.
You mentioned earlier that this investigation had several faults. What else was overlooked?
Well, I'm stunned that the police simply accepted the screenshots given to them by Alex Fuentes. Those screenshots could have been easily doctored. The police had the necessary tools such as Celebrite to verify these text messages, as well as the time to do so, but chose to accept them at face value. If you have technology like Celebrite and don't use it in a murder investigation, I'm not totally sure when you would.
Are there any other suspects that should have been considered?
I think so. A few months before Mackenzie Brackman's murder, he represented a man named Jonathan Rollins.
Objection, Your Honor. Hearsay and speculation.
Response.
Your Honor, as an expert, this witness reviewed a multitude of material in their preparation for this case, and from that drew their conclusions, and it's just relaying that information to the jury.
Your Honor, the only way this witness can testify about any sentencing hearing from Jonathan Rollins is through hearsay.
The objection is overruled. As an expert witness, Mr. Van Owen can testify as to hearsay he used to base his opinion upon. Go ahead.
Can you repeat the question?
Of course. Are there any other suspects that should be considered?
Definitely. A few months before Mackenzie Brackman's murder, he represented a man named Jonathan Rollins. Rollins was convicted and sentenced to life in prison, with his child Blair Rollins present at the sentencing.
And what does that mean in this case?
To me, it's pretty clear that Blair Rollins had much more of a reasonable motive to kill Mackenzie Brackman than Miss Avery Becker did. Yet the prosecution simply chose not to investigate Blair.
Where did Blair Rollins go to school?
Blair Rollins was a senior at Colorado High School last year.
And where is Blair now?
As of my knowledge, Blair Rollins disappeared immediately after graduation. The police never investigated Blair's location, and no one's been able to find him since.
What evidence is there supporting an investigation into Blair Rollins?
Blair Rollins and Avery Becker have a pretty similar body shape, and that's increasingly important when you remember that Mrs. Becker was never seen at Mr. Brackman's home. It was just a ring video of a masked intruder potentially matching the body type of Miss Becker. On the day of the murder, Blair Rollins was also absent from school, but had no alibi, unlike Miss Becker. Blair's disappearance would be a much more appropriate response for someone that just committed a crime, rather than Avery Becker, who stayed in town and continued with normal life. And at least in my mind, seeing your father be put away for murder is much greater motive than being kicked off of the mock trial team.
Objection, Your Honor. Speculation.
Response.
As an expert, this witness is entitled to his opinion and can speculate to an extent.
Your Honor, this witness says, as in my mind, Blair Rollins has a stronger motive because of the criminal conviction. This witness is testifying to thoughts and feelings inside of Blair's head and admitted that that is only their personal opinion and not something that they can connect to Blair Rollins.
If I may respond, Your Honor.
Go ahead, Mr. Chanel.
I believe the witness just stated that having your father be sentenced to prison is more of a motive than being cut from a mock trial team, and did not reference Blair directly. Just a general statement about motive.
I'll allow the testimony as long as it's an opinion from Mr. Van Owen rather than him saying what somebody else feels or thinks. Go ahead.
Well, as I was saying, based on many of my investigations in the past and dealing with motive in essentially every case I've worked with, I would say seeing a loved one be put away for murder is much greater motive than being kicked off of a mock trial team.
And looking back, how do you believe that this case was handled?
It was clearly rushed. It's clear that Detective Markowitz made up his mind and then sought evidence to support the conclusion. There was no physical evidence even placing Miss Becker at the crime scene, and this case shouldn't have even been brought to trial.
What do you want at the end of the day?
I want justice for the death.
Your Honor, relevance?
What is the relevance?
This witness is looking to state his reason for being in the courtroom today.
The objection is sustained. What he wants to see happen is not relevant.
Mr. Van Owen, what is your job at trial today?
My job was to complete my own investigation in order to fill in the holes, which there were many of in the prosecution's investigation. And based off of this, it's clear that Avery Becker was not the one that committed this crime.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. First, Professor Van Owen, you stated that the phone sitting inside of the fry shack could connect to all 3 cell towers. Do you recall that?
Yes, within that 6 to 7 mile radius.
You never state that in your witness statement, though, do you?
No, I'd say it could be inferred, though. 2 is less than 6 or 7.
You also said that Detective Markowitz did not conduct any form of an investigation into Blair Rollins, correct?
I don't remember those specifically being my words.
You inferred that Detective Markowitz did not conduct any form of an investigation into Blair Rollins?
While Detective Markowitz may have created some kind of investigation, it was not nearly good enough.
You did review Detective Markowitz's work in this case?
Of course I did.
So you are aware that on Exhibit 16, Detective Markowitz placed Blair Rollins' home?
Yes. I don't know that I can hear.
I think we lost Miss Kidder. Could you stop the time, please? Let's get Miss Kidder back. We'll give her a minute.
My apologies, Your Honor. I believe I froze. If the clock would be stopped during that time, then we can get that time added back to our cross-examination.
We stopped the time for you, Miss Kidder. Let's resume the time now. Repeat the question, Miss Kidder, please.
You know, because you reviewed Detective Markowitz's work, that Detective Markowitz placed Blair Rollins' house on Exhibit 16, correct?
Yes, that is the case.
Now let's talk about the work you did and did not do for this case. You never actually visited the crime scene, did you?
No, as a private investigator, I'm pretty limited in what I'm able to do, so I never was able to set foot in the crime scene.
And you also conducted what you called a partial investigation, correct?
Yes, an investigation which sought to fill in the holes of Detective Markowitz's investigation.
And for this partial investigation, you failed to obtain cell tower records for March 5th, 2020 to see whether Becker and Perkins were where they said they were?
Yes, and although I wish I could have, like I said, my resources are limited as a private investigator.
But you admit that you should have and could have obtained these records, don't you?
Yes, Detective Markowitz could have as well.
For your partial investigation, you also failed to get account records for Mr. Brackman's ring device, didn't you?
That's correct.
Next, let's talk about the issue of your more criticisms of police work. First, the scuff marks. You've stated that scuff marks like that could be left on a kitchen floor for up to 5 years. Isn't that right?
Yeah, I believe many of us could look on our kitchen floors and see scuff marks left from many periods of time.
And you said that they are the only apparent evidence of a struggle, correct?
I would say so.
You have heard the testimony today that there was a broken plate in the home, correct?
I did hear that testimony.
But you didn't mention that anywhere in your witness statement, did you?
No, I did not.
You don't dispute that testimony, do you?
Nope.
You also heard the testimony today that there was an overturned chair in the home, correct?
I did hear that testimony.
You don't mention that in your report either, do you?
I do not.
So you would agree with me then that actually visiting the crime scene could prove to be helpful in forming conclusions as to what happened?
It certainly would, but luckily a turned over chair and broken plate don't necessarily tell you who committed the crime like call records do.
Professor Van Owen, do you believe the plate could have also stayed on the floor for up to 5 years?
I would say certainly so.
How about the chair?
Most likely. However, I don't see anybody leaving a broken plate or a fallen over chair on the ground for 5 years.
And it is your testimony. You've seen the videos of the intruder, correct?
That is correct, as I reviewed the case files.
And it is your testimony that somewhere in that hoodie and sweatpants, the intruder was carrying a very sharp 12-inch chef's knife, correct?
Yeah, the clothing was relatively baggy. I'd say it wouldn't be too hard to hide that kind of knife.
And it is your testimony that the intruder who carried this knife into the house, planning to kill Mr. Brackman, left the murder weapon right there in the crime scene, correct?
Yes, left it inside of the victim's shoulder as they fled the scene.
But you do admit that there was a knife block on the counter that was missing one knife, which was large enough for a chef's knife, correct?
Yes, however, the brands of the knife used and the knives in the knife block simply did not match.
You also heard the testimony today that there was a knife drawer wide open in the home, correct?
I did hear that testimony.
Further, you admit that the size of the intruder is the same build and body shape as Avery Becker, don't you?
Yes, Blair Rollins and Avery Becker have very similar body shapes.
And you admit that the cell tower records show that the defendant may have been near the home during the time of the murder, don't you?
The defendant's phone may have been, yes.
Professor Van Owen, you've previously stated it is Investigation 101 not to assume things, haven't you?
Correct. The old assumptions horse.
However, don't you state it is likely Becker's phone was deactivated?
I would say so, based on my experience in my investigation of the phone records.
But you didn't investigate that, did you?
I was able to investigate what Detective Markowitz had looked at, as well as the case files.
You also believe the intruder carried the knife into the house, despite there being no evidence for that, don't you?
As I've said previously, yes.
And you believe that Blair Rollins could have committed this crime?
Definitely.
And you have no evidence that Blair Rollins harbored resentment towards Mr. Brackman, do you?
I believe seeing your father put away for murder is motive enough.
But you have no evidence of that, correct?
I'm not quite sure what kind of evidence you'd be looking for.
Any kind of evidence, Professor?
Not with me today, no.
No more questions, Your Honor.
Thank you. Mr. Chanel, redirect.
Mr. Van Owen, apologies. Is it your responsibility to conduct a full investigation, or is it the department's responsibility?
I find it to be the police department, specifically the Denver Police Department and Detective Markowitz's responsibility to complete a full investigation. My role in this case was simply to complete a partial investigation, one that could fill in the holes where Detective Markowitz missed out on a lot of key information.
And as seen in the ring videos, the perpetrator was seen rushing out of the home. Do you think, could this have provided the broken plate or fallen chair, or even the knife being left at the scene?
Certainly, yes.
And opposing counsel was harping on that. You mentioned that Blair could have committed this crime, pointing that there was doubt. Do you believe that there was more evidence towards Avery or towards Blair?
I'd say, considering the strong motive of Blair Rollins and the matter of circumstantial evidence in this case, I think fingers point to Blair Rollins.
And was there any evidence, any physical evidence pointing towards Avery Becker being at the scene of the crime?
No, no DNA, no photographs, no one saw Avery Becker at the scene of the crime. We're simply basing it on a masked figure and whether or not they brought a knife with them.
Thank you, Your Honor. No further questions.
Thank you. Does the defense rest?
Yes, Your Honor, the defense rests.
Are we then ready for closing arguments?
The defense is ready, Your Honor.
Okay. Ms. Keeter, are you doing the first closing argument?
Yes, Your Honor, I am.
Okay, go ahead.
Before I begin, Your Honor, I would like to reserve any remaining time I have for my rebuttal.
Yes, that's fine.
Motive to commit mischief, which resulted in a murder. The defendant had a motive for getting into Mr. Brackman's house and vandalizing it. Once she was inside the house committing this crime, which the law calls criminal mischief, she was surprised. And although she didn't intend to harm Mr. Brackman, a struggle ensued, and Mr. Brackman ended up with a knife in his back. His death is murder under the law. Good afternoon, members of the jury. My name is Rachel Kidder, and for the next few minutes, I will show you how the people have established beyond a reasonable doubt that Avery Becker is guilty of second-degree burglary and first-degree murder. First, under jury instruction number 8, the elements of second-degree burglary require us to prove that the defendant knowingly broke an entrance into or entered unlawfully in a dwelling with the intent to commit the crime of criminal mischief against another person or property. Criminal mischief means damaging the real or personal property of another person. Let's look at the evidence for burglary. The defendant had already vandalized Mr. Brackman's car and was planning something worse for the house. She outlined her intent to do so in the text you saw in Exhibit 14. You also heard the defendant tell her mother, "I will get back at Brackman if it is the last thing I do." The defendant's call detail records put her at the scene of the crime during the murder, and the ring security footage shows someone the same height and size as the defendant entering and exiting the home. The people have proven second-degree burglary. Next, under jury instruction number 7, the elements of first-degree murder require us to prove that the defendant committed or attempted to commit a second-degree burglary. And in the course of that crime, or in immediate flight therefrom, someone was killed. Here we have proven that the defendant's presence in the home was a second-degree burglary. The evidence showed the defendant was surprised by Mr. Brackman. may have even attempted to flee, but was stopped, a struggle ensued, and Mr. Brackman was killed. That, members of the jury, is textbook first-degree murder. When you review the jury instructions, you will see that motive is not an element of either crime, but it is an important factor in determining who did this crime. And we have shown you the substantial motive the defendant had by using her own words. You heard from Alex Cifuentes, Taylor Perkins, and even the defendant herself that she was criticized by Mr. Brackman, causing her to vandalize the car. Then when kicked completely off the team, the defendant planned to vandalize the house as well. Today, the defense tried to tell you that the screenshots and cell tower data weren't enough to prove the defendant was there. It is circumstantial evidence, we acknowledge that. However, under jury instruction number 3, the law treats both direct and circumstantial evidence the same. The defense also tried to tell you that the defendant lost her phone and didn't notice it was missing. Members of the jury, I would like you to think of all the teenagers you know that let their phone out of their sight for more than an hour. That list is non-existent, right? And finally, the defense brought to you an alibi witness, Taylor Perkins. Both the defendant and Mr. Perkins claim they were together all day on March 6th. Jury instruction number 4 tells us that you may believe all of the testimony of a witness, part of it, or none of it. You heard Perkins admit he met with the defendant after Mr. Brackman's death. That's when they created their story and coordinated their testimony. You also heard Perkins admit that he stepped down from the mock trial team to give Avery Becker what she wanted. Taylor Perkins is covering for his best friend, and you need to disbelieve his testimony. As for the defendant, you heard her admit that she lied to her own mother, and anyone who can do that can certainly give false testimony to this jury as well. You need to disbelieve her testimony. There is no evidence for this alibi. The evidence that was admitted in this case shows us that the defendant's motive to commit mischief resulted in a murder. Members of the jury, it is not the people's burden to prove to you that the defendant is a bad person. Of course, it's human nature to want to convict only bad people, but that is not an element of the crimes here. It is your duty as jurors to review the evidence and apply the jury instructions as the court gives you. The evidence does not show that the defendant intended to kill Mr. Brackman, but she did intend to commit criminal mischief and a death occurred. Members of the jury, after your deliberations, we ask that you find the defendant guilty of second-degree burglary and first-degree murder. Thank you.
Thank you, Ms. Skeeter. I need just a second my computer is dying. So give me 30 seconds to move out of the courtroom and plug it in. Hold on, please. Okay. Closing argument for the defense, please.
Yes, Your Honor. Framed evidence, faulty police work, and the fallacy that is this case. Your Honor, members of the jury, today we've heard the tale of Avery Becker, an innocent high school student who was guilty of nothing more than the occasional prank, and definitely not cold-blooded murder. I'm going to read to you a quote from author Katie Dowds, who analyzes similar cases to this very one in her books. And the quote goes as such: "A common belief that police and prosecutors hold that they intuitively know a bad guy blinds them to innocence." Your Honor, today the prosecution has overlooked the abundant evidence that proves that Avery is not and could not have been guilty of this crime. They presumed Avery guilty before they had analyzed any of that. Now, today the prosecution holds the burden of proving true to charges. And those charges, which were outlined by the prosecution in their closing, are second-degree burglary and first-degree murder. Your Honor, today the prosecution has failed to meet that burden. I would like to direct your attention to focus on the prosecution's main theme, which involved motive, mischief, and murder. Now, we don't dispute the fact that Coach Mackenzie Brackman was murdered. And we certainly don't dispute the fact that there was a lot of mischief laced through the prosecution's case. Now, let's talk about motive. We know that Avery, sure, Coach Brackman could be tough on her, but he wanted to see the best. Now, Avery could not have been at the crime scene. We know from Taylor Perkins that Avery was with Taylor the entire day. They were searching for Avery's lost phone. Additionally, it is introduced by Kyle Cusack a Ring doorbell footage, and this footage showed one person walk into Coach Mackenzie Brackman's home. Now, one person, Taylor Perkins was with Avery Becker the entire day. We know that as a fact. Not only were they not at Mackenzie Brackman's house, but if they were, they both would have shown up on that footage. Additionally, the only evidence that even remotely ties Avery to the crime is, again, from Kyle Cusack. It's that Ring doorbell footage. And it merely associates Avery with the murderer through a very general height comparison. Avery's face is blocked. We don't know the race or gender of the person who broke into Mackenzie Brackman's home. And we only know a very general height comparison. It's right next to a fence. There's a huge margin of error in those different types of comparisons. And you've heard today from expert Blake Van Owens, who proves that the prosecution failed to complete a full investigation by describing their confirmation bias. The prosecution entered this case presuming that Avery was guilty. They refused to change their minds after finding an abundance of evidence that proved otherwise. And Detective Markowitz, the prosecution's main detective, only spoke with one person, and that person was Alex Cifuentes. That's where the mischief lies in this case. Alex Cifuentes has always been a jealous rival of Avery Becker. And we have no proof that these text messages, A, were with Avery, or B, were made by Avery. The only evidence that suggests it was Avery was that the name was there. And as we all know, that can easily be changed by switching a few buttons. And we don't have the phone here to confirm whether or not she was actually texting Avery, if Avery was actually the one to send those texts, which she was not. Moreover, the cell tower data presented is a result purely of the faulty police work that we mentioned. And expert Blake Van Owens covers this. A phone left in the relative vicinity of the fry shack could have easily connected with all three of the towers without even being moved. Therefore, it shows no distinction between whether or not Avery had gone all the way. Now, let's go back to Kyle Cusack and his faulty wannabe police work. All of the claims made were, once again, tunnel vision from the very start, and they were based off evidence that was not there. Kyle Cusack agrees that they don't have the expertise to determine whether or not Avery was actually the one that was guilty or not. Your Honor, members of the jury, it is your responsibility today to determine who is guilty or whether or not Avery is guilty or not. And we believe that we have more than established reasonable doubt as to whether or not Avery could be guilty of that. Thank you.
Time.
Rebuttal closing.
Yes, Your Honor. Before I begin, I would like to have a brief time check.
You have 43 seconds left on my time.
Thank you. The defense today presented you with a theme: faulty evidence. There is no evidence that Blair Rollins had anything to do with this crime. There is no connection of Blair Rollins with this crime. Faulty investigation. Professor Van Owen did not complete a full and thorough investigation as the defendant hired them to do. And finally, fallacy. You heard that Professor Van Owen made multiple assumptions, even though they criticized the police for doing the exact same thing. Members of the jury, this entire case rests on the testimony of Taylor Perkins, who we have proven cannot tell the truth. That is why we ask you to find Avery Becker guilty. Thank you.
Thank you, Ms. Kidder. This concludes our trial here today. Everybody, that was just amazing work from everybody. So let's give some time to the score group. Is the score group coming back?